ಚೇಂಬರ್ ಹೋಗಲ್ಲ 40 ರೂಪಾಯಿ ಹಾಕಿದ್ದೇನೆ 40 ರೂಪಾಯಿ ಹಾಕಿದ್ದೇನೆ
What up, sir, madam? Madam?
ಅಲ್ಲ ಫಸ್ಟ್ ಮ್ಯಾಚ್ ನಿಜ ಆಗ್ತದೆ ಬೇರೆ ಮ್ಯಾಚ್ ನೆಕ್ಸ್ಟ್ ವೈಸ್ ತಾನೇ ತಗೊಳಲ್ಲ
So sitting 11 o'clock, sir? Yes.
Sir, at what time sitting?
11 it seems.
Madam, hall 29. Date ಕೊಟ್ಟಿದ್ದೀನಿ. ಹೌದಾ ಸರ್? Thank you.
Madam, court officer.
ಹಲೋ ಹೇಳಿ ಸರ್.
ಸರ್ ಉಮೇಶ್ ಅಡಿಗ ಸಾಹೇಬ್ರದ್ದು ಒಂದೇ ಎರಡು ಮ್ಯಾಟ್ರ್ ಇರ್ಬೇಕು, ಯಾವಾಗ ಕರಿತೀರಿ ಸರ್ ಅದು?
ಉಮೇಶ್ ಅಡಿಗ ಸಾಹೇಬ್ರದ್ದು ಮೆನ್ಷನ್ ಮಾಡಿ ಹೇಳ್ಬೇಕು. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮಾತ್ರ ತರಿಸ್ತಾರೆ ಫೈಲು, ಇಲ್ಲಾಂದ್ರೆ ಅಲ್ಲೇ ಡೇಟ್ ಕೊಡ್ತಾರೆ ನೋಡಿ.
ಓಕೆ ಓಕೆ ಸರಿ ಸರ್, ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ. ಓಕೆ
ಓಕೆ ಓಕೆ. ಈ ಲಿಸ್ಟ್ ನಮ್ಗೆ ಬಂದೇ ಇಲ್ಲ. ಲಿಸ್ಟ್ ಬಂದಿದ್ಯಾ? ವೇಟ್ ಮಾಡಿ ಸರ್. ಇವ್ರು ಕರೀರಿ ಅವ್ರನ್ನ. ಮೇಡಮ್ ಹೊರಟೋದ್ರ? ಒಂದು ಇಷ್ಟನ ಇಲ್ಲ ನಮ್ ಕಡೆ. RPFC ಇರೋದು. ಮೇಡಮ್ ಮೀಟಿಂಗ್ 11 ಗಂಟೆಗೆ ಬನ್ನಿ. ಸಪ್ರೇಟ್ ಇಟ್ಕೊಳ್ಳಿ. ಕೊಡಿ ಕೊಡಿ, ಅಲ್ಲಿ ಮೇಡಮ್ ಫಿಕ್ಸ್ ಮಾಡ್ತಾರೆ. ನಾವೆಲ್ಲ ಕೊಡೋದು ಅಲ್ಲಿ ಸಾಹೇಬರು ಮೇಡಮ್.
ಮೇಡಮ್ ಅವರೇ,
20 ಸಪ್ರೇಟ್ ಇಟ್ಕೊಳ್ಳಿ. ಹಿಂದಿ ಚೇಂಬರ್ ಓನ್ಲಿ. ಚೇಂಬರ್ ಬರಕ್ ಹೇಳಿದಾರಲ್ವಾ? ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ ಕರೆಯಲ್ಲ, ಫೈಲ್ ಅಲ್ಲಿ ಕಳಿಸ್ತೀವಿ ಚೇಂಬರ್ಗೆ. ನೀವು 5 ಗಂಟೆಗೆ ಬನ್ನಿ. ಚೇಂಬರ್ದು ಫೋನ್ ನಂಬರ್ ಬರ್ದಿದ್ದೆ. ಅಲ್ಲೊಂದು ಕಾಲ್ ಲಿಸ್ಟ್ ಒಂದು ಇದು ರ್ಯಾಪರ್ ಅಲ್ಲಿ ಇಟ್ಟಿದ್ದೀನಿ ನೋಡಮ್ಮ. ಫೋನ್ ನಂಬರ್ ಐತಿ ಚೇಂಬರ್ದು. 4186. ಹೆಸರು YN ಎಲ್ಲ ಬಂದಿದ್ವಿ. ಚೆನ್ನಗ್ರಪ್ಪ YN ಅಲ್ಲ. 11 ಗಂಟೆಗೆ ಇದೊಂದು ಫೈಲ್ ಚೇಂಬರ್ ಬೇಡಲ್ಲ
ಆಮೇಲೆ ಅಲ್ಲೆಲ್ಲ ಫಿಕ್ಸ್ ಇಲ್ಲ ಅಲ್ಲೇ ಇರಿ ಸರ್ ನಾನು ಮಧ್ಯಾಹ್ನ ಚೇಂಬರ್ ಇರುತ್ತೆ ಸರ್ ಅಲ್ಲೆಲ್ಲ ನಮ್ಮನ್ನ ಕಲ್ತ್ಕೊಂಡು ನಾವು ಏನು ಮಾಡ್ತೀವಿ. Pending and follow.
ಇಪ್ಪತ್ತೊಂಬತ್ತಲ್ಲ 4029 ಅಲ್ಲ 7029. ನಂಬರ್ ಇದೆ ಮಾಡಿ ಒಂದು ಲಿಸ್ಟ್ ಇದೆ ಫೋನಲ್ಲಿ ಇದೆ ಮತ್ತೆ ಕೊಟ್ರ
ಸ್ವಲ್ಪ ಮೆಟರ್ನೇ ಇದೆ ಸರ್. ಯಾರಾದ್ರೂ ಬೇಕಾದ್ರೆ ಡೇಟ್ ತಗೊಳ್ಳಿ, ಇಲ್ಲಾಂದ್ರೆ ಅವರೇ ಡೇಟ್ ಕೊಟ್ಕೊಂತಾರಲ್ಲ ಅಲ್ಲ ಸರ್.
ನಮ್ಗೆ ಹೆಲ್ಪ್ ಮಾಡಿ ನೀವು ಹಂಗಾರೆ.
ಇಲ್ಲ ನನಗೆ ಹೋಗ್ಬೇಕಲ್ಲಿ ಫೋಟೋ ಅಂತ ಎಲ್ಲಿಗೆ
ಇದೆ ಅಲ್ಲ ಒಳಗಡೆ ಹೌದೌದು. ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಸಿಟ್ಟಿಂಗ್ 11:30ಗೆ. 11:30 ಸಿಟ್ಟಿಂಗ್. ನೀವು ಬನ್ನಿ ಇವ್ರೆ ಕೋಟಾ 29 ಸರ್ ಅವ್ರು 29 ಕರೀರಿ ಅವ್ರು 29 ಅವರೇ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಡೇಟ್ ಕೊಡ್ತಾರೆ ನೋಡಿ. ಅಲ್ಲೇ ಕೊಡು. ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ವೇಟ್ ಮಾಡಿ. ಹೌದು.
For 11:30, the cases will be serial number 5.
Serial number 5 hit list.
Case list.
Hit list.
First.
Will be called serial. Sitting 11:30.
ಸರ್ ನಾಳೆಗೆ ಬೇಕಂತ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ? ನಾಳೆಗೆ ಬೇಕಂತ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು.
ಹೌದೌದು.
27ನೇ ತಾರೀಕು
ಅರ್ಜೆನ್ಸಿ ಇರೋದೆಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಡಿ, ಬೇರೆದೆಲ್ಲ ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ.
27ನೇ ತಾರೀಕು 27ಕ್ಕೆ
ಅಲ್ಲಿ ಚೇಂಬರ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತಾರೆ ಸರ್, ಓದ್ಬಿಟ್ಟು ಫಿಕ್ಸ್ ಮಾಡ್ತಾರೆ.
ಮೆನ್ಷನ್
ಪೇಮೆಂಟ್ ನಾವು ಕೊಡೋದು, ವೇಟ್ ಮಾಡಿ. ಸಾಕು ಬಿಡ, ದೇವ್ರಿಗೆ ಕಾಣೋದು ನೋಡು. ರೆಡ್ ಮುಂದೆ ಇರೋದು, ಒಂದು ರೆಡ್ ಇರೋದು, ವೈಟ್ ಇರೋದು. ಎಲ್ಲಿಗಡೆ ಫಿಕ್ಸ್ ಅದು ಹೊರಗಡೆ ಇದೆ ಸರ್. ನಾನು ಮುಂದೆ ಇರೋದು. ಚೆನ್ನಪ್ಪ ಎಲ್ಲ ನಂಬರ್ ಹಾಕ್ಬಿಟ್ಟ. ಇದು ಮ್ಯೂಟ್ ಮಾಡೋದು ಯಾವ್ದಮ್ಮ? ಇದು ಮ್ಯೂಟ್ ಮಾಡೋದು ಕೇಳಿಸ್ದಂಗೆ.
ಇಲ್ಲ ಸರ್, ಇದು
ಮಾಡ್ತಕ್ಕಂಥ
ಅದೆಲ್ಲ ಇಟ್ಬಿಟ್ಟು ಲಾಕ್ ಮಾಡ್ಬಿಟ್ಟು
ಪರ್ಮಿಷನ್ ತಗೊಬೇಕು ಸರ್, ಹಿಂಗೆ ತಗೊಳಂಗಿಲ್ಲ.
Hello, mic testing 1 2 3. This is quota number 20. Adalat here is being checked from a far distance. Hello, hello, hello. High Court of Karnataka.
ಡೇಟ್ ಮ್ಯಾಟ್ರದ್ದು ಒಂದು ಲಿಸ್ಟ್ ಹಾಕೋಣ. ತಿಲಕದ ಸುಮಲತದೊಂದು ನಮ್ದೊಂದು ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಲಿಸ್ಟ್ ಹಾಕೊಡಿ. ಅದೇ ಹೋಗ್ತಾರೆ ನೋಡಿ, ಪೆರಿದು ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಲಿಸ್ಟ್ ಮಿಸ್ಲೇನಿಯಸ್ ಡಿಸ್ಪೋಸಲ್ ತೆಗಿತೀವಿ. ನಾನು ಅವರಿಂದ ಹೇಳ್ಬೇಕಾಯ್ತು. ಇರ್ಲಿ ಬಿಡಿ. ಎಸ್ ಅಲ್ಲ, ಆಮೇಲೆ ಚೇಂಬರ್ ಕೊಟ್ಬಿಡು. ಎಸ್ ಇಲ್ಲಿ ಕೊಡ್ತಾರೆ, ಇನ್ನು ಆಮೇಲೆ ತಗೊಂಡೋಗಿ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾವಲ್ಲಿ ಡೇಟ್ ಪಕ್ಕ ಪೆನ್ಸಿಲ ಬರ್ಕೊಂಡು
My lord, it's a fresh matter. The response.
ಕೊಡಿ. ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ.
It may be posted today at 2. Yes.
Page wise adjournments, if any. List number 1, serial number 1 to 3. Page number 2, 4 to 11. List number 1.
Serial number 11. For the respondent.
For petition. No, for petition. 11. No, it's announcement. Well, for the announcement of the.
Why do you want adjournment?
Again, another case.
Also, I will see that. Yes.
Pass over. Serial number 2 ಹೇಳಿದ್ರಲ್ಲ.
Serial number 10, my lords.
Serial number?
10. My lords, matter referred to mediation, my lords, on 30th of this month. There is a chances of settlement, my lords. After that, any. Please, my lords. For the respondent.
Submitted the matter pending for mediation. This is matter. This is matter on
26th of November.
My lords, interim orders there.
Interim order earlier granted is extended till then. Yes.
Serial number 9. I'm appearing for respondent. The arguing counsel son is not keeping well, so is unable to attend the court.
Inform the other side.
Yes, we have informed the other side.
Yes, this is matter on 27th,
Maybe the matter may be taken up post 20th of November, my lords.
27th. If I look at it, if interim order is extended at the request of then counsel, the respondent is
Page number 3, 12 to 14. List
Yes.
number 2, page number 1 and 2. Page number,
Is coming up for orders, we'll see. Yes, next. Don't call orders matters.
yes, ma'am.
Yes.
Page number 2, 4 and 5. Page number 3, 6 to 11.
My lords, serial number 10, my lords. I may be permitted to withdraw the writ petition, filing a memo to that effect, my lords. I have informed the other side as well, the respondent.
For the respondent.
What was the interim order in this?
There is no interim.
There's no interim order.
No interim.
I'm withdrawing the petition.
Yes. The memo is filed to withdraw the petition. Dismissed as withdrawn. Yes, next.
Please, ma'am.
My lords, serial number 6. Serial number 6, my lords.
6 in second list.
Yes.
Yes.
My senior's grandfather has been died, my lords. Kindly have it on 1 week. My lordship, my senior's grandfather has been died today, lords. Kindly have it on 1 week adjournment.
List the matter on 4th of November. Huh? Copy of the writ petition shall be served on the council for the respondent. Yes.
Cause list number 2, my lord, serial number 4. I'm sorry, my lord, serial number 4. I am for the petitioner, my lord. I'm yet to inform the other side, but my lord, it may be posted on Monday or Tuesday, my lord.
You have an interim order?
My lord, on Saturday, my lord, if possible.
You have an interim order, I said.
Yes, my lord, I have an.
We will see.
Yes.
When the matter reaches.
Yes.
Yes. Yes.
List number 3, serial number 1 to 3.
Serial number 9, my lord, list 2. I'm for the petitioner, my lord. The petitioner seeking 1 week time to decide, my lord. So kindly have it on next week, my lord.
No, these DRT matters will not be adjourned. Yes.
List number 3, page number 1, 1 to 3. Page number 2, serial number 4.
Serial number 3. List number 3. 241 of 25. There is an IA mailer.
So?
So delay for 885 days.
That you will mention now when the matters are called. Yes, call
No,
the list.
the lower court is issued NBW and as well as.
So what to do now when the matter, when the list is called, then you have to argue.
Adjournments.
Now it is for adjournments.
For adjournments.
Yes, next.
Next week. Ma'am.
Page number 4.
Serial
List number 4.
Serial number 4. I am for the petitioner in the first matter. I intimated to the other side.
Which case?
Serial number 4 in third list.
Number 4.
Their petition is also there, madam. One of my relatives said I have to go, madam. I intimated to
Both
the
these
other
matters list in the month of December. Yes, at the request of Lord Counsel, the petitioner. Yes, then call. Make it fast.
Yes. List number 4. Page number 10, 31 to 35. Page 11, 36 to 40. Page 12, 41 to 47.
47. No problem. Admission matters will, insurance company is there. We will print and we'll ask somebody to take, we'll admit it. No, you don't have to argue. Yes. Let it be there.
Page number 13, 48 to 56. Page 14, 57 to 62.
62, my lords. I'm
Yes.
for the appellant, my lords. Claimant's appeal, my lords. Kindly a week time may be granted, my lords. As seen it is
No,
out
it's
of
coming for admission. It will be admitted and the lower court records will be called.
my lords,
Yes,
so
no
finally-
adjournment in this.
so
Nothing to argue now. It will be admitted. Yes.
Page number 15, 63 to 67. Page number 16, 68 and 69.
Let's call the list.
List number 1 for order, serial number 1, Jairaj ji.
The petitioner shall comply with the office objections within a week. And also the office objection with regard to the maintainability of single writ petition in view of section 7 of the writ proceedings rules is upheld and single writ petition is not maintainable. It's a default order. Within 1 week, the office objections shall be complied with, or else the petition shall stand dismissed without further reference to the court. Next.
Seal number 2, Ajay Prabhu.
No, my lord, the advocate on record is not in station, my lord. I
In
seek
this
for,
also, you can't maintain a writ petition.
may I seek for Monday, my lords?
The petitioner shall file 2 separate writ petitions in
Please.
respect of the separate IAs.
Please.
It shall be done within a week, default order.
Please.
Yes, 3.
3, MD Raghunath.
I appear for the petitioner, my lords.
10.
My lords, just one humble submission with respect to that. It is an interlocutory order, my lords. Under section 19 of the Family Courts Act.
We're not going into all that. Now the difficulty is.
Please, my lords.
When you question 2 orders.
Please, my lords.
When we are dismissing, writ petition is 1.
Please.
We have to dismiss 1 IA. Several times it has come up for being spoken to. That's a practical difficulty.
Please.
So please file 2 writ petitions in respect of 2 IAs. That's a simple thing.
I understand.
Yes, the petitioner shall file separate writ petitions in respect of 2 IAs. Yes.
My lords,
Next,
a date may
within
be-
a week. Within a week.
A date
If
may be
you
fixed,
have,
my lords.
the moment you file it, it will come.
The-
List this matter once the separate writ petitions are filed.
Please,
Or you can restrict this writ petition with regard to 1 IA.
Please, ma'am.
And for the other you can do.
If I may be permitted to do so, my lords.
Whenever you do it, it will come.
The only problem is, my lords, in the trial court, it is on the 3rd of November.
3rd of,
November.
list this matter on 31st, on 30th.
Please, my lords.
Yes, next.
Much obliged.
Seal number 4, Arun Govindraj.
The respondent was supposed to make the payment of the school fees. Memo.
Hmm? 2,31,600 is paid.
Total 5,29,000. Madam, I'm filing a memo. I've also given my learned friend the receipts, all the payments made to the school so far. It's 5,29,000 rupees. Still 2,97,000 rupees is due from the father to be reimbursed to the mother.
Lead counsel for the respondent submits that he has paid an amount of rupees 2,31,600. Then counsel appearing for the petitioner submits that still an amount of rupees
2,97,615.
2,97,000.
615 is to be reimbursed to the mother.
615 is still to be paid to the mother. Then counsel for the respondent submits that within a week.
He's also in a financial difficulty.
What is the impugned order?
1.5 crores, my lord, is his income. 1.5.
Let's see, then we'll pass the order in the main petition.
Challenges to the visitation.
Let's see.
But the respondent has to comply with your lordship's order, my lord. He's not complying at all. But more than 2 months now, my lord. 10th of September was the order passed by your lordship.
No, that's what.
Yes.
We'll not give him any time. We'll pass a final order.
This was passed on 10th of September 2025.
You said it was not communicated.
No, I could not communicate because it was not uploaded in the website. As well as what I could not just prior, 1 day prior to the order in respect of child's appointment with the therapist. That order may be what we can comply with that.
But we have sent an
And there is a communication by the therapist also not. The communication by the
No, before you go into all that, what is the impugned
The
order?
challenge, the order of visitation, my lord, family court is going to pass an order allowing the father to have visitation every day from every Sunday from 8 a.m. to 8 p.m.
What is the age of the child?
So she's 15 years old.
Hmm.
But on the last occasion, my lord may recollect, I read the therapist's report, the complaint filed by the mother, not before the police, where the child was requesting the father to spend time, and the therapist directed, my lord, the respondent to allow the petitioner and the child to move away to a separate house because the child had developed suicidal tendencies.
Remember that?
Yes.
Hmm. So, in the interregnum, what has happened?
Your lordship passed an order on 10th of September directing the father to meet the child in the presence of the therapist, starting from 24th of September. Email is sent to him, giving him the therapist's telephone number, address.
Let's see, where is that order?
10th of September, your lordship's order. Paragraph number 8. Mary, paragraph 8. The father is permitted to exercise visitation before the same therapist, Ms. Mallika, with whom the girl is presently undergoing therapy sessions. Subject to the availability of the therapist, the father is permitted to exercise visitation every week for 2 hours, and this shall go on for 4 weeks, which shall be subject to availability and appointment of therapist and the girl. It is stated that the exams of the girl will be completed by 24th of September. Thereafter, for a period of 4 weeks, the father shall exercise visitation as directed. After completion of the said period, therapist shall address
What
the
happened after this order?
He is not. An email is sent to him with therapist's email address, phone number, and the contact address. Absolutely no response.
May I request what kindly see the communication made by the therapist herself.
Have you met the girl from that day? Why?
Not the order which was not available, and the detailed order is there. That it has to be communicated. I have informed my client saying that these are the orders the court has passed now, and we have to go and meet the therapist and.
So it appears that your client is really not interested to do anything.
He is ready to do everything, Lord. There is no communication.
Now, if really is interested, the day the order is passed, what has transpired in the court? He must have asked you. He asked you. You informed him, but you technically say that the order is not uploaded. That's why he couldn't do. If he's really interested to do, he would have done it by understanding from you what is happening, what happened in the court.
I go out your lordship's observation, but the detailed order will not specifically says from which date they have to start counseling and all. But that will not be available only in the order, which was not available with me also. Therefore, Lord, now I am requesting what to kindly fix the date. From now onwards, 4 weeks, Lord, we will definitely not, we will immediately if the order is provided, we will communicate to the therapist and we will start. Because Lord, the therapist.
Any IA is filed for the educational expenses and all before the trial?
Maintenance application is pending.
It's on. He has filed a statement of assets and
Yes,
liabilities.
it's posted
As
for
per the
arguments.
assets and liabilities, what is his income?
1,56 lakhs.
Then how are you denying it now?
I have
it. Please pass it on.
I have the income tax returns.
Lord, there is a dispute in respect of Lord with regard to earnings by the petitioner also.
No,
They
income
have not
tax,
furnished anything before the
income tax returns, there cannot be any dispute. Income tax returns.
1,56 lakhs is declared income.
He has more liabilities, Lord. Kindly see, on the last occasion, my learned friend have provided the income tax returns papers, which itself shows, Lord, where petitioner is residing in a house, flat, which was in fact not purchased by the respondent. And Lord, when completely Lord, there is no access to the property, Lord, whichever Lord he is, has purchased along with the petitioner. Lord, petitioner, Lord, is enjoying the entire property, Lord. In fact, Lord, the respondent is residing in a rented house. And he is taking care of his aged parents, Lord, both are Lord, the chronic, they are suffering from the chronic disease. Lord, father is going to Lord, dialysis twice a week. So there are difficulties, Lord, and Lord, all the liabilities, Lord, has been paid by the respondent. The house, EMI, and the flat, the site, which was also Lord, purchased, in fact, Lord, by petitioner and respondent. The entire
No,
EMI
we are concerned with the child, the child's maintenance.
I'm not denying, Lord.
No,
There is a compliance of the order of this one.
A person whose income is more than 1 crore, whatever all the expenses, let's take into consideration. In spite of that, I don't think it will be difficult for him to pay this educational expenses.
He is having some difficulty. He is expressing his difficulty.
That difficulty is his intention not to pay.
No. And the deductions and all, they have to look into that because the father, not the respondent, he is not taking care of his old age parents. They are not spending much the medical expenses on this.
Who will take care of the child?
He is ready to take care.
But how he will take care? Again, we are coming back to the same issue. No, the court has already said this is, then you said something like the order copy is not, no, we will tell him, then what about the remaining amount? You were saying that it is difficult. We'll say within 2 weeks he has to pay the remaining amount. And as per the earlier order, we'll fix a date now. Why don't you, before order is passed, why don't your client find out the availability of the therapist for the first session?
That what the therapist has emailed, was on the 22nd October yesterday.
When she is ready.
No, that they have not, they only said that she was on leave because of the festival. And the communication is made on 22nd October. But I will also ask my client to go and meet personally and get the.
And we'll also ensure that the order copy is uploaded.
Please. That please, my lord.
Yes. So, yes, Mr. Gondraj, when is the date?
She says Wednesdays, not midweek, she's available any day.
Wednesday. That's on
29th.
29th. Time?
Time, they will communicate, the counselor will communicate to both the parties on email.
Please come. Doctor will not be available after your working hours.
Because the school, the child will be going to school and father will be working.
Is it so? 6 o'clock? She works at 6?
She does not work. She has.
Not she, the
School,
the counselor.
No, she. Around 4:30, the counselor will communicate. She said usually around 4:30 are the sessions, midweek. The counselor will communicate to both parties.
On 10/9/2025, this court has passed an order. Para 8 of this order reads as, thus you please extract paragraph number 8. The land counsel for the petitioner, petitioner mother submits that the father has not made any efforts for the visitation, for meeting the child or for going with the counseling session. And he has paid only an amount of rupees 2,31,600 and is yet to pay an amount of rupees 2,97,615. Land counsel appearing for the respondent father submits that though the order was passed on 10th of September, as the order copy was not uploaded within time, the same could not be communicated to the respondent father. It is submitted that he is ready to exercise the visitation and the remaining amount also he'll be paying in a short time. It is submitted that though his salary is 1 crore and odd, he has certain liabilities and also he has to take care of the aged parents. As such, he is finding it difficult to pay the entire amount at one stretch. It is submitted that on which date you have received the communication?
Communication made to the.
Communication from the counselor.
That is on 22nd October.
He has received a communication on 22nd October from the counselor. They'll be appearing. And as per the order dated 10th October, they'll be exercising the visitation. Accordingly, this court is passing the following order. Within 2 weeks from today, the father shall pay the remaining amount of rupees.
4 weeks. I don't know what is it.
You don't know, but with this order of the court.
Let them go on with the counseling.
3 weeks, within 3 weeks, the father shall pay the remaining amount of rupees 2,97,615. And both the parents, the father shall also go to the therapist, Ms. Mallika, with whom the girl is presently undergoing therapy sessions on 29th by 4 o'clock. By 4 o'clock. He can exercise the visitation there itself for 2 hours. And this exercise shall go on for a period of 4 weeks. After completion of the period, the therapist shall address shall send a report to the registrar judicial. The same shall be placed before the court. Yes. This is matter on 2nd of December. Yes.
There are not miscellaneous, not expenses, not
whatever amounts that are paid are subject to the further orders of the court.
And let there be action brought with regard to what any miscellaneous payments are made by the petitioner. But that should be brought with consultation of the court. There is no consultation at all. They straight away brought, they are not putting child in such a tuition fee and all. They are claiming that, let them claim. I'm not denying that, but at least they should intimate the father, not where the child is going
We'll
for
see.
tuition center.
First, let this happen. We'll see.
Please.
No, fine.
No, the third term fee is due on 30th of November, my lord, that he has to pay directly to the school.
I think, no, 30th of November, 30.
Is the third term, my lord.
No, but I said 4 weeks. That 4 weeks will complete, 3 weeks. 3 weeks will complete by 21st of November.
That's the reimbursement to the mother, my lord. On 30th of November, the final term school fee is due 1,64,000 rupees.
20.
It is not, sir. It is not. It is not.
Look at it.
It is not. I filed a memo, detailed memo.
The next, in the one of the condition, the next last condition, by 30th of November, the third term fees of the child shall be paid by the father without fail.
Right.
Yes. Next.
Number 5, Nehru MN.
Yes.
In this case, I am for petitioner, please, my lord.
Who appears for the respondent?
In this case, my lord, we are challenging the interim order. That is the ex parte interim order. I already submitted before your lordship that the respondent wife, she's
How much?
living
What is the amount granted?
10,000 rupees. It's not that she's living with the adultery. And she's living with the adultery, and at the time of passing that order, she has stated that the two children was residing with her, but that both the children are residing with me. And apart from that, one of the daughter, she has filed a sexual harassment case against the paramour of the respondent, my lord. So that it has to be considered, I may be permitted to heard the matter. Whatever the
What is the interim order?
10,000 rupees has to be paid.
Interim order.
Interim order.
Impugned order is?
No, interim order. No, not impugned order.
Where is it?
1,50,000 rupees has to be deposited. That has to be deposited.
Please come to the impugned order.
71, page number 71, my lord.
As per the impugned order, you have to pay 10,000.
10,000.
Is there any interim order passed by this court?
Yes, please, ma'am.
Where is that order?
Dated on, it is passed on, dated on 30th of 38 2021, subject to deposit of 1,50,000 rupees before this honorable court next week within 6 weeks. List the matter on. We are complete the order 7/1/2023. Now they have filed an application for withdrawal of the application, withdrawal of that amount. So I am objecting since from the, because it is an ex parte order. I may be permitted. Detailed objection has been filed. All the document has been filed. The POSCO, in the POSCO case,
Why it was an ex parte order? Ex parte order is passed.
This one, the impugned order is.
Why when you
Because
not
during
present?
2021, I was suffering from COVID, my lord. I am not able to come before the court.
The order passed. Dated?
Order passed on 21. 27/8/2021, my lord.
2021.
21, my lord.
There was no COVID that time.
No. I was suffering. I was suffering COVID. I have produced document also before the court. Subsequently, after that, I filed the detail. But in spite of that, the court has been already passed the order. They have filed an execution petition. My humble submission before, even 10 days, 15 days time may be granted. I mean permitted to heard the matter before, whatever the order, if it is passed subsequently after hearing the entire argument as well as the looking into the documents, I am ready to abide the orders passed by the lower court. That is my humble submission.
Michael Mathur.
Next week, Your Honor.
Your Lordship, kindly see, whenever the matter has been posted, different advocates is appearing, their own petition, divorce petition, they only filed. That has been stalled on account of this.
On 19/8/2025, when this matter came up, there is no representation on behalf of the respondent. No representation on behalf of the, no order. No representation on 22/7/2025, 18/7/2025, 10/6/2025, 5/4/2024. Why there was no representation?
Senior is not here, ma'am.
Mrs. Mata, as partner tomorrow. Yes.
Number 6, Jyoti B.
I'm filing a memo for withdrawal of the petition.
Take that. Memo is filed stating that the MC number 251 of 2021 is withdrawn. And MC number 1 of 2021 was decreed on 13/2/2025, which is filed for restitution of conjugal rights. Hence, the present memo is filed.
In view of the same, we are filing the memo.
Hence, the present memo is filed accordingly. Memo is taken on record and the writ petition is dismissed as withdrawn. 7.
7, Satyarthi. Satyarthi.
Yes. You please give the file first.
For the petitioner, my lord.
Yes.
We're challenging the maintenance order directing the.
What is granted?
18,000, my lord, but the petitioner is just a scholarship student who was earning around 42,000 stipend.
42,000.
And as of now, October his stipend will end, my lord. He's no longer entitled to receive the stipend. So he'll now be a guest lecturer, in which case he'll be only allowed to teach 12 hours per week. That is at a maximum.
So you're worried about what will happen after?
No, my lord, from November itself, not. Till now he's got 42,000 and he is paid.
So he is able to pay till now.
He's able to pay
So
now.
please take notice to the respondent. We'll see.
Okay.
The petition is permitted to take court hand summons on the counsel appearing for the respondent and shall file a memo to that effect. Once the memo is filed, this is matter. Yes, 9.
8. Praveen S.
Yes.
For the petitioner, my lordship.
Yes.
We filed a present writ seeking speedy disposal of IA number 2, my lordship. There is a suit for declaration.
Which court is this?
My lordship.
Which court is this?
This is the family court, my lordship.
That I know. Where is it?
Bangalore, my lordship. Family court, Bangalore. My lordship.
I think there are so many family courts in Bangalore. First additional, second, third. Which court is that?
This, my lordship, is pending before the. One moment, my lordship. This is before the second additional family court, my lordship.
Your prayer must be there. Look at your prayer.
Just looking at my prayer, my lordship. Fourth additional family court, my lordship.
Fourth additional. Which year is the
2023, my lordship.
IA is filed when?
IA is filed by the petitioner here in my lordship, seeking not to alienate the suit schedule property. There is jointly owned property between the spouses, the petitioner and the respondent. The respondent has not contributed towards the jointly owned properties.
What is the suit? You have filed a suit.
We have filed a suit, my lordship, for declaration
in the year
and.
2023.
My lordship.
In the year 2023.
22, my lordship.
22.
I stand corrected. 22.
IA is filed in 23.
22, my lordship.
22.
22 itself.
What happened from there? From 22?
They've been
not
seeking
till now?
adjournments. They've been seeking adjournments.
Let's see where are the proceedings?
The order sheet, my lordship,
Hmm.
is an ink page and some notice. 51, my lordship. 51 onwards, my lordship. 52, my lordship, the trial court has issued emergent notice in page number 52.
No,
There are-
emergent notice was issued on 14/10/2022.
That is right, my lordship.
Then,
Thereafter, in page 53, my lordship,
let's see what has happened. When have you entered appearance?
I'm the petitioner, my lordship. I'm the person who's filed the suit.
A defendant, when the defendant has entered appearance.
That is in the next page 53, my lordship, 25/1/2023.
25/1.
2023. Therein, in the last para, it is noted, my lordship.
Hmm.
Now later, advocate for plaintiff opposes the adjournment on the ground that in view of the emergent notice on IA number 2 and also the defendant having appeared and taken time and other two cases are pending between the same parties, there is urgency in the case. Hence, adjourned for objections on IA number 2 finally on 4/2/2023. Thereafter, my lordship, the next day's proceedings are in 54, 4/2/2023. There also it says for objections on IA number 2 and written statement by 15/2/2023. Something similar transpires on the next date also, my lordship. Page 54, my lordship, the second portion. States that they haven't received a copy of the IA. 55 also, my lordship. Copy was served again. 56 also they have taken time. On 2 dates, my lordship.
Please come. The present writ petition is filed seeking the following prayer. Extract the prayer. Then counsel for the petitioner submits that he has filed the suit in the year that is OS number 379 of 2022. And along with that, he has also filed an IA seeking a direction to the respondent not to alienate the suit scheduled property. It is submitted that right from 2022 till now, on the request of the respondents, the court is continuously adjourning the matter, and the IA is not decided till now. Then counsel has drawn the attention of this court to the proceeding sheet, which shows that the matter is adjourned on several occasions. It is submitted that the purpose of filing the petition itself will be defeated if the same is not heard and passed, and orders are not passed expeditiously. Next para. This court has perused the order sheet as well as the pleading, as well as submission of the learned counsel for the petitioner. When an IA is filed seeking injunction in the year 2022 on various grounds, the matter is adjourned and the IA is still pending. In the interest of both the parties, this court deems it appropriate to direct the family court to dispose of IA number
2, my lordship.
IA number 2 within a period of 2 months from the date of receipt of the copy of the order. This court is not proposing to issue notice to the respondent as no adverse orders are passed, and the disposal is in the interest of both the parties. Yes.
Oblige, my lordship.
Accordingly, writ petition is disposed of. Yes, next.
9 and 10 urgent. 11.
Yes.
Charanappa.
For petition, my lord, the trial court has been passed the order of maintenance to the petitioner and child, my lord,
Respondent.
5,000 rupees. That is, the order is the page number 85. My lord, they have produced the
Then
bank.
counsel for the respondent shall place a 3 years bank statement. It's placed.
They have produced only 2 years bank statement.
Huh?
2 years bank statement. It shows that in the kindly see page number 7 that he was getting the salary plus incentives, my lord. That
How
is
much?
33,000.
What is
Yearly
the,
works,
They disclosed only 20,000 rupees,
salary
what
particulars
is
has been
the
furnished.
amount that is granted by the family court?
5,000 rupees. Because child is 5 years old,
3
he
years
has to
old.
admit him
Child and mother or only for the
Only
child?
only
child.
for the child, my lord.
Mother is working.
No, she is not working, but not avoided for the mother, my lord. Only
He
for
is
the
a
child.
graduate.
You have sought for maintenance to the
Please,
mother also.
mother and also child.
So wife it is denied, child
Please,
it is
yes,
granted.
please,
So you seek an enhancement for the child and maintenance to the mother also.
please, please.
Yes.
Only 3 years old, that is a child. She is a graduate of MA, biotechnics. She is a part-time lecturer in the self-earnings is there. She has not produced the
What is her qualification?
MA, my lord.
Huh?
MA.
no, MSA, PhD. That is there in the state
Yes. Now presently she is studying MA.
lecturer.
Earlier she was
Not
graduate.
concerned with what is she
Please,
pursuing?
BSc graduate.
What's her qualification? What is the acquired qualification?
Please, BSc, my lord.
MSA is also there. Objections.
Yes, that is admitted fact. Because of the child, she is not going to the work. Because she is the only person to
3
take care of
years
the
old,
child.
the child is there.
After
Court
the,
has correctly granted the ongoing school in.
Why it is not granted to the wife?
because my lord, kindly see.
Lecturer is there.
No. Kindly see the page number 11, observation of the trial court.
Where is it?
Page number 87, my lord.
87.
Please.
Para number 14, it is stated.
So it makes out that since the year 2019, the respondent was working for Dayanand Sagar University. There
Read
is also,
paragraph number 13.
please. The respondent had filed her affidavit for disclosure of assistant liabilities, whereby she had disclosed her educational qualification as MSc in biotechnology. She is resting in her parents' house and they got separated on 5/12/2021. Her general monthly expenses is shown as 25,000. Her daughter Rikti, age 3 years, is dependent on her with regard to her employment, designation and income. Respondent disclose as not applicable. That is observation by the trial court. But she has left the job 2019 after the marriage, my lord. After that, she did not work anywhere. This is also part-time job, my lord. And the trial court observed in the para 14, my lord, page 11.
Your income is 33,000 or 24,000?
20,000, 23,000 after deduction 20,000. I have filed my salary particulars also.
Then what is that he referring in the bank account that you're getting 33,000?
Only 33,000 is intensive, only for 1 year, like that. The company will give insurance.
Once in a year. Once in a year.
Once.
No,
So that's only one entry.
No, not like that. There are so many entries because
Let's
please, page number 7, 4/2/2023, he was getting 5,000.
Let's see.
5,000 rupees.
Alala, I am calculated on the same month how much he was received from the employer. 4/2/2023, that is one entry, and 10/2/2023, that is 20,000 rupees, another entry.
That is
And
salary.
10/2/2023, 1,333 melo. After that, melo, 28/2/2023, 5,096. And after 28/2/2023, 999, my lord. And next page, my lord, 8/11/3/2023, my lord, 1,333, my lord.
What are all these entries?
This is incentives, my lord. Because he is a sales executive, when he sell the automobiles, he will get the benefit, that he will get the incentives.
What is the salary? What are the incentives?
Incentives 10,000 rupees and salary is 20,000, my lord. Because entry is showing, my lord.
Where do you find that entries? I'm looking at page number 7.
Please.
What is the date?
My lord, page number 7, my lord, the first entry is A4/2023, 5,096.
There is no page number 7. There is no.
No,
4
in this, my lord, they have filed the bank statement.
When at 5/2/23, 5,000 rupees intensive was there.
In their bank statement.
5,000 rupees. There is a, only a sale product is there. They will give.
For that month, it is only 5,000.
5,000, and that month he was received 33,000 total, apart from salary, and he has received incentives. And next month also he received 30,000.
Very month I
if
have not
calculated.
received intensive.
No, it is showing that their, Allah, next month,
No company will give every.
Allah, next month, kindly see the page number 8, other next month 8/3, 8/3/2023, he has received 1,033 rupees. 333. After that, he received 31/3/2023, 8,288 apart from salary.
Please come.
Please.
This writ petition is filed. Agreed with the orders passed in. I number 3 in MC number 6285 of 2022, dated 2nd September 2025, whereby the court had granted maintenance to the daughter at 5,000 per month and refused to grant maintenance. As far as the wife is concerned, had refused to grant maintenance. The petition is filed. MC is filed by whom?
Please, husband, my lord.
Husband seeking
Please.
divorce.
Divorce.
Please.
In that, wife has filed I number 3 seeking maintenance of an amount of rupees 40,000 per month. For her and for the daughter, and litigation expenses of rupees 40,000. According to her, she's unemployed and she has no source of income. She requires an amount of rupees 40,000 per month. And as per the case of the wife, his salary is 20,000 per month. It is her case that the husband's income is around 7 lakhs per annum. He has his own accommodation. He also has his ancestral properties. The court, considering the income of the husband at 20,000, has granted 5,000 to the child. When it comes to the wife, the court has observed that she is educated.
Master degree, lecturer.
She is educated. She has done a PhD and she is capable of maintaining herself. Nothing has been stated why she is not working, and accordingly, not granted maintenance to the wife. Learned counsel appearing for the wife submits that though the wife is qualified, as she has to take care of the child, she is not working, and the court ought to have taken this into consideration. It is submitted that as per the order passed by this court, the respondent has filed his statement of has filed his 2 years bank statement. In that, it is shown that every month in the 20,000 income and another 10,000 towards incentives the petitioner, the respondent is getting. When that is the case, the amount of 5,000 that is granted by the court is not a just and reasonable compensation. It is submitted that on all counts, the amount of maintenance that is granted needs to be enhanced, and the wife is entitled for maintenance. Next para. When counsel appearing for the respondent husband submits that his salary is 20,000. The court had rightly considered this aspect and granted 5,000. When it comes to the incentives, according to him, he'll be getting it once in a year, and every month. No company will grant the incentives to the employees. It is submitted that he has denied the submission of the land counsel for the petitioner that she's getting an amount of rupees 33,000. It is further submitted that the wife was working as a lecturer, and those aspects were suppressed before the court, and the court had rightly held that she is not entitled for maintenance. It is submitted that the order that is passed by the court is a well-considered order, and it requires no interference from this court. Next paragraph. Having heard the concerns on either side, there is a material on record. As far as the wife's entitlement is concerned, the court had rightly considered the fact and rightly rejected the case of the petitioner, and this court do not find any reasons to interfere. Then coming to the salary of the husband, according to the husband, it is 20,000. As rightly pointed out by the land counsel for the respondent, the entries do show that the income is above incentives or whatever it is. His income is 30,000 and above. Though it is denied by the land counsel for the respondent, the bank statement speaks, the bank statement speaks otherwise. The wife, even if she has to work, even if assuming that she is working, she has to take care of the child. Admittedly, the child is aged about
5 years, ma'am. 5 years. Now
5
presently
years
5
as
years.
of now, and as on the day the application is filed, she is 3 years old. Considering all these facts, this court deems it appropriate to enhance the maintenance by another 2,000, that is 7,000. Accordingly, the court is passing the following order. The order dated so and so, passed by so and so is modified, and the amount of maintenance is enhanced from rupees 5,000 to 7,000.
Much okay.
Yes.
Number 12. Abhilash.
Appear for the petitioner, wife, my lords.
Yes.
Impugned
the
order,
impugned
my lords,
order?
would be at page number 93. Husband's petition for divorce before the trial court. Here the wife has approached this honorable court based on the impugned order. Husband has filed seeking divorce under 13(1)(1)(a) on cruelty, my lords. If my lords were to kindly turn to page number 94.
No, where is the impugned order?
94, my lords. It starts at 93.
The main petition, 2 sets also filed. Respondent is by directed to furnish the copies of the document. Call on for rejoinder.
That's 94.
I'm
That's the
looking-
first matter. 658.
6286.
6286.
I'm looking at 6286. Page number 94 is order dated 30/10/2022. What is the date of the order?
That's impugned order is dated 25th of January 2025.
It is not that. That's not the order.
In which case connected matter is there. 6286. 6286 I'm referring to.
I'm also looking at 6286. But the page numbers are not the same as you are referring.
Annexure
Check
K.
annexure.
Annexure K, my lords.
Yes, 25th January 2025.
Please, if I may, can you read the
That operative portion is at 92, 91. Memo dated filed on behalf of the petitioner is
Please.
allowed.
Please.
That's the impugned order.
That's the impugned order.
You are the petitioner.
Please.
Petitioner,
Petitioner before this court. No, I am the petitioner herein, respondent
Husband.
before the trial court. Wife, my lords.
you are the wife.
Please.
Who has filed the MC
MC is filed by the husband, who is the respondent herein.
seeking
Divorce on the
on the
grounds
ground
of
of
cruelty. Please.
Then what happened?
Now, my lords, what happens is there is a direction. If again, I have been prejudiced, is my respectful submission. What has happened is whether the matter should be considered in its entirety. What had happened was, my lords, there's a conciliation that is done by the court. On 16/3/2023, my lords, the family court passes a specified order telling that the matter will, both parties are actually directed to lead evidence only in terms of the maintenance amount. Because what had happened is the wife had also, by virtue of filing a counterclaim before the trial court, she had also sought for divorce. So post the conciliation process, the court passed an order telling that both parties seek for divorce. Therefore, both parties are only directed to lead evidence in terms of maintenance, because in the counterclaim, there's also a child from the marriage. So only in terms of quantum of permanent alimony as well as maintenance, the parties will have to lead evidence. That was the order that was actually passed on 16/3/2023, my lords.
Yes.
My lords, I'm afraid that the page numbers are not tallying.
Paragraphs, refer to the paragraphs.
Please, if I may read the impugned order in its entirety, if I may please.
No, entire order not this.
Very well, ma'am. Now, what has happened is, if my lords were to kindly see, after post that order being passed, both parties, that is the petitioner as well as the respondent, have led evidence. They have been cross-examined as well. When the matter was posted for the arguments, I have also filed my written
Filed this memo.
by the husband. That is the petitioner before the trial court. That is right towards the fag end of the entire litigation. They filed a memo telling that the matter should be considered in its entirety upon the merits of the entire case. However, if my lords were to kindly see, I had also filed two specific applications. I had sought for divorce on the grounds of cruelty as well as adultery as well. Where, my lords, I had filed IA number 5 as well as IA number 6. IA number 5 would be pertaining to the call records of the husband, including the location, whereas IA number 6 was filed towards the hotel records, where it is my very specific contention that the paramour as well as the petitioner had checked into the said hotel. That application, my lords, gets rejected based on the order of 16/3/2023, which basically said that parties will have to lead evidence only in terms of the maintenance aspect. Those two applications having been dismissed on the contention that there's a prior order of 16/3/2023. Now, post these applications have been rejected. After I have addressed arguments, during the course of me addressing arguments, the court once again says, no, we'll consider the entire case upon its merits.
Where is your memo? Where is your memo?
Memos at Annexure H, my lords. I'm afraid the page numbers might not tally, but in my indexation, it is page number 90, Annexure H.
Why the court is making it so complicated, and why the parties are making it so complicated for them?
Certainly not, my lords. What had happened was, in fact, I had filed a maintenance application along with IA number 5 and 6. I had come up before this honorable court seeking for a direction for disposal of those applications. The High Court, my lords, this honorable court, my lords, felt deemed it appropriate to direct the entire matter to be disposed of within a time-bound manner of 6 months. Then that aspect was also communicated to the Honorable Family Court. At
No,
which point of
where
time,
is that memo?
Annexure H, my lords.
Page 90, please, Your Lordship. That's not, I don't.
My
see
sincere
that
apologies
90.
that the page numbers are not tallying.
Yes, please, give him the papers, pass over.
Your Lordship, I think
May I request,
strangely, after 70,
Please,
it goes straight to.
we'll see, pass over.
please.
Give it to him to check the numbers and all, to correct it.
Missing.
And their copies also. Yes, next. Next.
Seal number 13.
I appear for the petitioner,
Okay,
my lords.
Yes, who appears for the respondent?
My lords,
Yes.
I appear for respondent. In fact, what had happened, my lords,
Where
an
is the
application
order?
that is at ink page number 143, my lords. Annexure G. An application came to be filed by the petitioner, my lords.
Petition is
Petitioner is the father.
allowed.
Unfortunately, it has been dismissed, my lords. Initially, it was allowed. They had not filed an objections to my application, IN number 8, for temporary custody of the child.
141 is the impugned order.
Please, my lords.
It is number 2 filed by the petitioner is partly allowed.
IN number 2 and 8, my lords. IN number 2 with respect to visitation, my lords. IN number 8,
Filed with the petitioner without any provision, hand over to him and also seeking intimation, initiation of criminal proceedings is hereby dismissed.
please, my lords.
What is that IN number 8?
IN number 8, my lords, is for temporary or interim custody of the child, my lords. What had happened,
What is this
If-
criminal proceedings?
that was like a contempt, my lords. If I may bring to my lord's attention to
No, where is the
annexure.
order? Where is the
Please.
contempt?
Please, my lords. I shall show to my lords with respect to ink page number 65.
How can both of them will go together?
I understand, my lords. In fact, if I may bring to my lord's
Contempt
attention
is altogether a different procedure.
different procedures, of course.
If that you're seeking under IN number 8 is different.
Different. In fact, there are two. In fact, if my lords may kindly peruse ink page number 65. my lords. This is the order passed by the trial court on 12/10/2023.
Yes.
Please, my lords. It says in the para number 3, sufficient opportunity is given. Objections to IN number 8 not filed by the respondent. The respondent has also not produced the child before the court in spite of the orders of this court. Heard and perused. In the interest of justice and equity, since the petitioner is the father of the child, IN number 8 filed by the petitioner for interim custody of the child is hereby partly allowed. The petitioner is entitled for the interim custody of the child for admitting the child in the school in Bangalore and during vacation pending disposal of the main petition. Unfortunately,
Where is the mother?
mother has gone to Singrauli, my lords, in Madhya Pradesh. During the subsistence of the proceedings, which is at ink page number 60, my lords.
May I please,
Earlier
my lord?
any matter is filed?
No, my lord. Mother.
Any writ petition before this court?
Yes, my
my
lord.
lord.
We have challenged that order, my lord, before your lordships, my lord. It is at page number 80, my lords. Your lordships were pleased to remand the matter back to the family court and permit us to file objections to IN number 8, my lord. Accordingly, we have filed objections to IN number 8. This impugned order came to be passed, my lord, which the petitioner herein has challenged. It is at page number 80, my lord. What has happened is that, my lord, while this impugned order is passed, which my learned friend referred at page number 65,
My lord's observations is there in para number 7, my lords, at ink page number 79. That the respondent has been deliberate in not producing the child. At para number 7, my lords, 12 lines from the bottom.
So first, why should a child of 6 years shall be removed from the company of the mother and shall be given to the father?
I understand. The only reason is this, my lords. If my lords may kindly peruse Singrauli, it's a town, my lords, in Madhya Pradesh. In fact, if I may bring to my lords' attention to Annexure F, my lords. I had filed a compilation of the research work done by the Niti Aayog itself, my lords, by the central government, wherein they have clearly mentioned that the schools at Bangalore.
What is she doing there?
But she is a doctor by profession, my lord. She is practicing there at Madhya Pradesh Singrauli, my lord, which I have taken clear contention.
When did she leave Bangalore?
But at 2022 itself, my lord.
No,
During
no.
the at the time of filing, she came here for pursuing her MD, my lord, at Bangalore. At a point of time, she was working at Manipal
When we
Hospitals, my
filed
lord.
the JNWC,
My lord, please. my
was
lord.
she here?
No, my lord. She was at Madhya
I'm
Pradesh
sorry.
itself, my lord. I have
My
taken
lords, may
clear
kindly peruse
contention
page number
at page
60.
at page number 41.
There's an
my
order passed
objections
by the
for that.
trial court.
Now the court will decide whether giving custody to the father is necessary in this case or not. Once the main GNWC is decided,
Please,
we
ma'am.
cannot pass an order saying that because Madhya Pradesh, she is a, what is your education?
He's working in a software company, my lords.
Yes, she's more educated than you.
My lords, MBA has been done by the petitioner. But I may bring to my lord's attention to ink page number 60, the conduct of the respondent, ink page number 60, my
But
lords.
that we will consider, No, we are on the first point,
Please,
shifting the interim custody of the child, which is not feasible.
The reason being it's this, my lords. If I may bring to my lord's attention to ink page number 99, my lord.
Just because, like, no, the mother will go to Delhi. Mother will want to go to US because there are better opportunities there. Then what should happen?
If
Will
that
you
is the case, my lords,
denied the complete visitation also.
my lords, there are two aspects to this. One aspect is this, my lords. Assuming for the sake of arguments, my lord, that the wife or the mother goes to the US, the father would not have any problem, my lords, because the opportunities for the child is much more in US. Secondly, my lords may kindly peruse that,
Only we will not look at things only in terms of opportunities.
my lords, the child is 6 years old, and what kind of a state the child is living at, my lords may kindly peruse at ink page number 99. This is the school quality index, my lord.
99.
This has been drafted by the research team of the central government, that's the Ministry of Human Resource Development, Government of India. At 101, my lords. The relevant portion is at 104.
Yes.
And this is an education quality comparison between the schools at Bangalore and Singrauli, my lords, which is where the child has forcibly been put up, my lords. Wherein, my lords, may kindly peruse, there are certain various facets. One is being an educational institutions. They say that Bangalore is much better having.
Where is he studying?
At Singrauli, my lord, Madhya Pradesh.
What is the school? What is the curriculum in that?
But, as far as he is concerned, my lord, my learned friend is referring that he is comparing both
That
cities,
will
my lord.
not,
That please, my lord. Those documents I'll produce, my lord.
It's in a government school, my lords. I have produced that in 108. The school name, my lords. Ink page number 108. It is called DAV Public School.
It's not a government school, DAV public school.
No doubt, my
This
lords.
is not a government
Initially,
school, my lord.
when the child,
Public school you have in Bangalore also. You have everywhere in the country.
I'm unaware of that DAV Public School at Bangalore, but my humble submission is this: the child, when the child was in Bangalore, the child was at a school which was having an international reputation, and the father was paying the bills, my lord. And the father till date is ready to pay the bills subsequent or to the aspect, my lords, where the child can study at a well-reputed international school. In the end, a father wants only the welfare of the child to be looked into, my lords. That is why the application came to be filed before the Honorable Trial Court, seeking a interim custody of the child for the purposes of having the child being admitted at a very well-reputed school.
Here, is that her native place?
Please, my lord, it is her native place, my lord, Madhya Pradesh, which at the point of time she was residing at Madhya Pradesh, my lord. To pursue her studies, she was residing at Bangalore, my lord. At the time of filing this, the GNLC petition itself, my lord, she was relocated to Madhya Pradesh, my lord.
So she's
Knowing
studying,
very well,
no, no. She, being educated in Madhya Pradesh, Shingoli, she could do her MD in Bangalore.
May I make a humble submission? My learned friend has not
comparing, my lord,
revealed the
my lord,
actual
many people who have
aspects.
studied in government schools have gone up to very level, good positions and all of this, my lord.
Let's not
I'm
look
not,
at-
it is
let's not-
comparing the
let's-
cities is not.
Let's not go into all the great people. Let us only look at his mother.
I'll go with that aspect itself, my lords. My lords, may kindly peruse ink page number 60. This is the order sheet, my lords, showcasing the conduct of the respondent mother,
That I
wherein,
have seen. That we will ask him.
my lords, the child was available and present in Bangalore when the petition was filed. Subsequently, she removes the child away. My lords, may kindly peruse the third
Has
paragraph.
she honored the orders of the court?
She doesn't.
My lord,
Did she come to Bangalore? Did she come along with the child to
please, my
Bangalore?
lord, she was
No.
present very much before your lordship as well, my lord.
Then after
And
that.
please, my lord, after that,
Was he granted any visitation?
please, my lord.
When?
My lord, we have, no, my lord, what has happened is that the court has granted video call visitation, my lord, which the wife is apparently in a matter of letter and spirit, she is abiding by the orders passed by this court as well, my lord. Now, whenever the father visits to Madhya Pradesh, she is giving visitation to the child, my lord. Even at a point of time, father is not visiting the child at Madhya Pradesh as well, my lord, which have taken clear contention in the statement of objections as well, my lord. Considering all these aspects, the
No,
court
this
has passed.
IA is seeking visitation interim, the visitation is allowed. What is
Please,
granted by the court?
My lords, there was an
Video
order
calls
passed
of
by the
30
trial court that on
Once
every
in a
Saturday
week.
and Sunday, the petitioner father should have a video call between 5 to 6. That came to be challenged before my lords, and my lords had rectified it and also amended the said order by my lords order passed just prior itself, my lords, wherein my lords have clearly held that every day the father will have the visitation contact rights from 5 to 7 in the evening, my lords. But unfortunately, till date, they do not do so, my lords. Unfortunately.
My lord.
In fact,
Then we'll do one thing. If you
My lord,
say,
I am complying the orders passed by this court by letter and spirit, my lord. I'll file an affidavit to that effect, my lord. Each and every call recordings
No,
which
what
is
we'll do is-
recorded by
no,
the
no,
wife
no,
as well, my lord. Because every time and again,
please wait.
Please,
What we'll do is, we'll list this matter after 2 weeks.
please, my lord.
As per the order of the court, you please, whatever, if you say that you are adhering to the order of the court, then please place before this court.
Please.
You record the entire visitation.
Please, my lord,
But
I'll
then
record.
what
Please,
will
I'll,
you
In fact,
in
may I make
fact, content petition is coming up on 30th, my lord. We are directed to file affidavit to that effect, my
Anyhow,
lord.
whatever,
I'll place
whatever
both on
that has
record.
to go on, it will go on.
Please kindly have it
But
after 2 weeks, my
we'll
lord.
adjourn it by 2 weeks.
Please,
may I
my lord,
make a
I'll
humble
place on
submission,
record
my lord?
everything, my lord.
The
All the
same
documents.
contention was taken by my learned friend on the last hearing date itself, my lords.
Of what?
On the last hearing date before my lords,
Saying now.
they say
No,
they
let-
will.
No,
Please, my
what
lords.
is it? That's the only solution for that.
Right,
You
time
want-
and again, my lord.
You want to have the access to the child. Now, according to you, she is not giving the access. That is by way of video call and all. Now, according to him, he is giving. So what we do is, I'll adjourn this matter by 2 weeks. And you, as per the order of the court, you have every day from 5 to 7.
And which they are not
That's what.
continuing, my lords.
So further,
Even-
you have to listen to the court, what the
I
court is
understand.
saying. 5 to 7. And they have to place before this court by the next date of hearing after 2 weeks that every day how the video calls have gone between 5 and 7 every day. So that it will cut the issue.
I understand.
There cannot be any dispute on that.
I have to bow down for that order, my lords. I'm okay for that. My lords, may kindly peruse one other aspect to it. Apart from the contact rights, I'm also seeking for an interim custody. The reason being, if I may bring to my lord's attention to,
Again, please don't go back to that.
my lords, I'm not
rules
going to
and-
the order. What the respondent has done at annexure H at ink page number 145. My lords, may kindly peruse. She has filed an application before the court at Singrauli.
The child is residing with the mother from when exclusively.
My lords,
My
after
lord,
filing of this
apparently,
petition,
he is not paying any maintenance, my lord. So that is the reason I have filed.
When?
My lords, may kindly peruse.
No, if the father takes care of the,
No, he is not paying, my lord.
please.
Please. I
All advocates have more anxiety than the parties. You don't
No.
even listen to what the court is saying. No,
Please, sorry.
if the father is ready to take care of the entire educational expenses of the child and put him in a great so-called whatever school he says, is there any difficulty for the mother to come here?
No, my lord. What has happened is that mother is residing with her father, my lord. Her mother passed away, so
He won't
he
come
will not-
along with her.
No, my
Where
lord.
in the
It is
interest of-
causing
she'll
difficulty
also
for
have good
because now the
prospects.
child is going to the school at Madhya Pradesh and she has been accompanied to Madhya Pradesh, my lord. It is difficult for her to relocate, my lord. The same question was put up before this court in 2024 as well, my lord. This court interacted with the mother and considering both the aspects, then the impugned order has been passed, my lord. Now she has been residing at Madhya Pradesh for a
No,
more
this is
longer of
about the
time.
visitation,
So-
the video call. What about the physical visitation?
Physical
when we-
visitation, whenever the father comes to the Madhya Pradesh, my lord, we'll permit him to access visitation, my lord. There is
And
no
even,
difficulty in mother giving the child.
Diwali holidays also gone now.
Lord, he has not filed any application, Lord. This is the first time he is bringing contention before this
My
court.
lords,
Lord. Let him file an application
already
before the
there.
court, my lord. When he want visitation, we'll look.
That IA which is dismissed, will pass some order in the coming Christmas vacation where the mother shall come to Bangalore.
Please, my lords.
No,
that
my lord,
can
let him-
happen.
That time we'll pass order. So before that, I'll adjourn this matter by 2 weeks till 2 weeks is today's
23rd, my lord.
23rd. We'll have this matter on 6th of November. Till
Please.
6th of November, that 5 to 7 shall go on.
I'll place
Tell
it on
your
record.
client, otherwise she has to face the music.
No, my lord. I'll place it
May-
on record, my lord.
May I make a humble submission, my lords?
So the petitioner submits that, yes.
Apologies for intervening. If I may bring to my lord's attention to one aspect in page number 145, Annexure H. She says that she does not have money to take care of the child. She puts up a petition before the Honorable Court at Singrauli, saying that she does not have the money to take care of the child. I may bring to my lord's attention to the relevant portion at 150, my lords, in page number 150, para number 12.
My lord, I have stated clearly, my lord, that the income of the applicant number 1 is not sufficient, my lord. I am not anywhere, stated in my affidavit that I am not earning, my lord. It is not sufficient for my livelihood, which I have stated, my lord. Admittedly, the father is not paying any single rupee to me, my lord.
I'm ready to take care of the
It's
child.
not
my lord.
sufficient.
No, whenever mother seeks maintenance from the father, custody should be shifted.
It's not like that, my lords. My lords, may kindly peruse. This petition was filed subsequent of the GNWC petition filed by the father
What is this petition?
to seek
This
for
maintenance
maintenance.
petition, my lord. Maintenance, he's not paying single rupee to the wife, my lord. That's the reason she has filed maintenance application before Madhya Pradesh.
Pending proceedings, you have not sought for any transfer, isn't it?
Please, my lord. No, my lord. I saw transfer before Supreme Court, my lord.
And that has been dismissed.
It has been dismissed, my lord.
Then how can you file an independent case there?
My lord, because admittedly now the place
You
of
cannot,
residence was at.
pending proceedings or in this GNWC, the IA has to be filed here. How can you file an IA there? How that IA is maintainable?
Please, my lord. I'll withdraw it because presently the mother and child were residing at Madhya Pradesh. She has filed the application there.
This is 125 CRPC.
Please, my lord.
This is what the mother
Why
is
would
doing.
she
my lords.
settle the issue? Why? What is the purpose of fighting like this? And
fact, we also
both
made
when she
certain
is not in a comfortable position to take care of the child, and when the
No,
father is comfortable, and he'll be. I'm not saying anything about shifting the custody. If she is in Bangalore, good for all of them.
No, we also tried many things, my lord, but things couldn't work out. She is also very accustomed to Madhya Pradesh, and it is very difficult for her to relocate to Bangalore, my
But she could study 2 years here in Bangalore.
lord. During her studies, she is located here, my lord. In
She
fact,
was
she is
staying
also
in
resident of
Bangalore,
Madhya
my
Pradesh as well, my lord. The petitioner husband. So now, admittedly,
She was
he has,
residing in
resided
Bangalore.
The present petition is filed, question, or the order impugned, whereby the application that is filed by the father seeking interim custody of the child is rejected by the family court. Then counsel for the petitioner submits that the mother has not complied with the orders passed by this court. This court had earlier passed an order permitting the father to have the video call access with the child every day between 5 and 7. That is also not complied with by the mother. It is submitted that the father is ready to take care of the entire expenses of the child. And earlier, before moving to Madhya Pradesh, he was studying in a good school. And now he is in a government school. He's studying in a government school. Then counsel appearing for the respondent mother submits that the mother is residing along with the father, her father in Madhya Pradesh, and it's difficult for her to move here. It is submitted that they're complying with the orders passed by this court, and the father is having the access to the children, to the child through video call. Video call. Next para. Considering the submission of both the parties, this court deems it appropriate to pass following order. One, the both the mother shall adhere to the earlier order of giving access to the father through video call between 5 and 7, and the entire the call shall be recorded and the same shall be placed before this court. This shall go on till 6th of November. This shall go on till 5th of November. Does this matter on 6th? Any violation of the orders passed by this court will be viewed seriously. Yes.
What's up, like? 14, Vanita?
Appearing for the petitioner, my lord. My lord, senior has some personal inconvenience. Someone has demised in the family. One day accommodation may be given, my lord. Tomorrow the matter may be taken up.
This matter, the family court has awarded the maintenance amount of rupees 20,000 per wife and 20,000 per child, and considering their income of 2,22,000 and add. So they have at the ground, they have not considered the profession and bank accounts of the wife, but in the specific para number of impugned order, clearly consider all the grounds. Then nothing will be.
Oh, why are you arguing? They have to argue whether it
But
can be
just
adjourned or
they
not
are
is the
dragging
point.
the matter, they are keeping the, moreover, they have not been interim order in fully. They are still due for 2 months.
Yes. This court has passed an interim order on 9/9/2025. Land counsel for the petitioner submits that there's some inconvenience to the arguing counsel. The land counsel for the respondent submits that the interim order is not complied with. If the interim order is not complied with, as it is a conditional order, the stay granted by this court stands vacated, and the respondent is always at liberty to execute the order. List this matter on 18th of November.
Okay.
Yes.
List number 2, serial number 1, Ashwin.
For petitioner. Lord, the petitioner here is challenging the annexure at page number 16.
Who appeals to the respondent? Murthy SR.
Murthy SR, respond number 1.
Lord, there is a interim order granted by this honorable High Court on 15.
You were not present on the last occasion.
Yes, madam, because actually I am representing the petitioner counsel, one Praveen Kumar. He appeared on with NOC Wakalat. He has admitted to hospital last occasion.
Yes,
For
let's
thought
see.
operation.
Let's see the what is the order impugned.
Annexure A, sale notice.
Why should we entertain this?
No, they already interim order granted by this honorable. High Court,
Now I
my
will
lord.
decide this
They have
finally.
complied the interim order.
Correct. Why should the sale notice be interfered by this court? What is the reasoning given in the earlier order? Let us see.
Is on 26/9/2025, my lord.
26/9.
2025. Last granted the interim order and by directing to deposit the 2,59,000.
This court granted interim order on 15/4/2025.
Oh, that earlier grant 15/4/25.
Notice to respondent. Due to
Petitioner
financial
could not
stringency,
comply
the
that order,
petitioner
then
could
he
not make
filed an
payment of the
application
due
for
amount.
extension.
Is 12,97,504.
Yes.
That is 2,59,000 within 4 weeks from today.
Yes,
That
was
is on or
deposit-
before 31/5, failing which the interim order shall stand vacated automatically.
That could not comply within 31/5. Then after filed the application for
First
extension.
is, this court has no jurisdiction to deal with this case because you couldn't point out what is wrong with it. Your financial issues are not the concern for the court to invoke the
He
jurisdiction under
deposited, my lord.
226.
Now the interim order also extended.
No, why should we do it? Is the question. And there should be some timeline. And when you say that you are ready to pay, if it is 12 lakhs, whatever is outstanding, if you say that I will do it in 2 months, 3 months, passing an order, I can understand. But with a meager amount, why should we pass interim orders?
No, my lord, but however, is it comply to the orders?
To understand, we can't interfere in these kind of matters.
Lord, but the counsel for petitioner is not well. He's taking rest. Kindly have it no, next week or 10 days time maybe.
This is matter under the same caption, under the same caption, on 10th, no representation for the respondent.
Millard, he is admitted in hospital and taking rest because
Who?
it was operated. Counsel for petitioner.
I am talking about counsel for the respondent. He is not present, that's what I said. And I am adjourning this matter under the same caption. That day we will hear.
Interim order maybe.
Yes, interim order earlier granted is extended. List this matter on 11th November. Yes, next.
Number 2, Lakshmi Narayan for respondent bank, my lord.
Well, for petition in this matter, my lord, on the last date of occasion, this honorable court has been directed to deposit an amount of 4 lakh rupees before the Bajaj Housing Finance Limited at Chikbalapur branch, and liberty also has been given, my lord. When we approach the branch, my lord, that they are not accepting the amount.
My lord, this present loan has been assigned to ACRE, my lord. We have handed over the letter to them.
What is the outstanding loan?
Outstanding is 6,93,273 as on 4/12/2024, my lord.
6 lakh?
93,273 as on 4/12/2024.
My lord, the loan amount was taken 9,25,000, my lord.
Where?
My lord, since 2 years, the petitioner number 1 is suffering from stage 4 cancer, my lord. She is taking treatment at Basavatarakam Hospital at Hyderabad, my lord. For that reason, my lord, she became an NPA, his loan asset. Now, my lord, after that, when they have been approached before the trial court, my lord, under section 14, that we have filed an objection stating that the principal component, whatever the amount, my lord, the loan amount was 9 lakhs, my lord. We have till date paid 12 lakhs. Another 4 lakhs, my lord, we are ready to pay. That they are not accepting the amount before the trial court even, my lord. None of them that have
Please
been
tell
appeared.
one thing, can the court under 226 compel the bank for any one-time settlement?
Not one-side settlement, my lord. In the last date,
Settlement.
of hearing, my lord, this honorable court has been directed to appear before the branch and to pay the amount.
If there can't be any direction for them to accept it.
Yes. We have provided the bank details of ARC also, my lords, to hand over the amount to them.
After this order, my lord, that they have been sold this property to somebody.
My
Some
lord,
that setting the third party, my lord.
it was sold on 23rd September 2025, my lords.
After passing of this interim order by this honorable court,
No, my
directing us to pay the amount, my lord, that they are making all the hectic efforts, my lords, to making all these things. We are ready to settle this amount, my lord. We are ready to pay, but unfortunately, they are not ready to receive this amount and settle this matter.
According to them, the outstanding is 6,93,000.
Yes, my lord.
273 on 4/12/2025. No, but it is a year now.
Yes.
My lord, we were ready to pay since last 6 months, my lord. Unfortunately, they are not entertaining us.
No, when he's ready to pay the amount, what is the bank's interest to sell the property?
My humble submission,
No,
my
they are
lord.
not sold the
My lord, their
property,
intention is
No.
there is a insurance amount.
That when he is ready to pay,
Yes, ma'am.
he is not seeking for any reduction of interest or anything. He's saying whatever is outstanding, I'll pay. What is the difficulty?
How
of
he
the
has
bank?
approached to bank, my lords, to settle entire amount. By the time we have sold this account to ARC, my lord.
No, my lord, this honorable court has been granted an interim order on 9/10, my lord. But they have sold this property and after subsequent to this interim
My lords,
order.
23rd September, the account has been sold to the ARC. my
That
lord.
is prior to this.
Prior to this
prior to the
interim
order.
order.
But they have no communication with us, madam. No
Notice
such
has
communication
been
has
sent
been
to-
passed with us.
To send to the customer.
It
my
has
lords.
come up for the first time when
Yes,
this
madam.
order is passed.
Yes, ma'am.
It doesn't, there is nothing is recorded about their submission in this order.
Around 9/10 that they have appeared.
9/10 order.
Yes, my lord, they have appeared on 9/10, my lord.
Where is that?
The same, my learned friend has been appeared before the court.
Liberty, nothing, nothing has been recorded in the
But
order.
though it was not recorded, my lord.
So what do you expect the court to do now? That you please tell.
My lord,
Now,
we are,
according to you, now according on 23rd is September 2025, that is assigned to some
Yes.
asset reconstruction company.
yes, my lord.
Now, this order is passed on 9/10/2025.
Yes,
That is subsequent, that is much prior to this order.
yes. My lord,
Let them impute
Prior
ARC,
to,
my
prior
lord.
to that, we filed objection before the trial court and we clearly said in our objections that we are ready to settle this amount, whatever the principal amount due. In spite of that, they have not received. Then we have approached before this honorable court.
How can you say the principal amount?
My lord, there are 2 more years to pay, my lord. There are 2 more years schedule is there for us to pay.
Whatever is outstanding as on that day.
Yes.
Yes, yes. After 2 years, even we have 2 years to pay that entire amount. But the principal amount, we are ready to pay it now itself.
Then you approach company. No, nothing is with them.
My lord, kindly permit us to implead them as parties.
Huh?
Implead them as parties.
File it in the registry, not here.
Please, please. My lord, the interim order is there. Kindly extend the interim order.
Bajaj Finance will be.
Then you are not, because they will come and of course list this matter on 10th of November. Then comes for the respondent submits that. Thou never assigned it to
ACR, Assessed Care Reconstruction.
Asset Care Reconstruction Company.
Enterprise Limited.
Then counsel for the petitioner submits that he'll file the complete petition. List the matter on November 6th. By the time the complete petition is not filed, the petition shall stand dismissed without further reference to the court. The interim order earlier granted is extended till then. Yes, next.
Bill number 3, Chetty Vignesh.
For respondent 1, 2 and 5. The petition, my lord, is a nationalized bank. My lord, the short point is involved in this matter, my lord. The short point is involved in this matter. I sold the property, my lord. I'll just nuances of the matter is this. 2020, my lord, the subject property, my lord, created a mortgage in my favor. Tell the exact date.
2000?
My lord, dated, my lord, 27/3/2020. And registered mortgage is
27/3/2023.
20, my lord, 20. Registered mortgage is created in my favor on 27/4/2020. That is, my lord, annexure A.
Yes.
Page number, my lord, 19. It is not in dispute.
Hmm.
Thereafter, my lord, the borrower is not added out the terms of, my lord, sanction. I classified the account as NPA on, my lord, 29/1/2022.
29/1?
2022.
24.
21, 2021. No, my lord, 22. 29/1/2022. 22. Thank you.
Chronological order of events.
Yes, please give that.
And I issued a 13-2 demand notice under, my lord, Surface Act.
Look at those, whatever he has given, the chronology.
In fact, very same thing.
What the case? The loan account of so and so has become NPA.
All, my lord, dates are, my lord,
Notice on 6/5/2022.
My lord, thereafter, I conducted the auction. There are multiple occasions, my lord, I put the property for auction. In fact, all the dates, my lord, I mentioned in my petition. And, my lord, finally, I sold the property in favor of, my lord, the my lord, connected petitioner, writ petitioner. On, my lord, 31/3/2024. That sale certificate, my lord, can find it at, my lord, page number 28, annexure B.
Oh, it is attached under the.
Attached, my lord, subsequent to my mortgage, subsequent to my 13-2, wherein, my lord, my act is, my lord, central legislation. There, my lord, state legislation. My lord, thereafter, my lord, the auction purchaser given a representation to the sub-registrar to register the property.
Now it is a fight between whom?
Between me and, my lord, the KPID authority. My lord, it is I am obligated to, my lord, hand over the property as well as, my lord, registration. I had to get it registration of the sales certificate in favor of the auction purchaser. He paid, my lord, more than 7 crore rupees. My lord, that to, my lord, in the year of 2024, March 2024. Now, my lord,
Lost permission, my lord.
1 minute, I'll just complete. Two more submissions. I given a representation before the, my lord, jurisdictional SRO on 30/3/2024. They replied, my lord, annexure C, page number 30, saying that there's an attachment.
Application is dated 29/3/2023.
Please, my lord.
Your sale confirmation is?
My lord, I issued a sales certificate on, my lord, 31/3/2024.
33.
Okay, 33. My mortgage, registered mortgage.
It's on 27/4/2020.
2024. No, my lord, 2020. Much before, my lord, in fact, all the crime or whatever complaint, my lord, Lord Jagan.
What is the full form of this act?
Karnataka Protection of Interest of Depositors Act and
Oh.
Financial Establishments Act, my lord.
Yes.
This, my lord, question fell for consideration of the Honorable Supreme Court. Because every state, my lord, every
come to
state,
that.
my lord, has a similar act which are almost pari material.
No, it is not so.
No, let him complete. We'll see. I
I'm so
can't
sorry. I'm so
understand
sorry.
what
I'm
is
so
your
sorry.
point.
I'm so sorry.
But the dates, my lord, would not be as important in as much as, my lord, the question fell for the consideration before the Honorable Supreme Court as to whether the concurrent attachment before, my lord, between SURFACE Act and, my lord, the MPID, which is parameter with my provision, I provide, my lord, the provisions of both the act, which will prevail over the other. So the argument that my learned brother is now raising, that that is a central enactment and hence will prevail over, has been exhaustively considered by the Honorable Supreme Court.
See that?
Please,
Where
I
is
have
the
produced along with my lord's my compendium.
In fact, I produced last week.
Yes, where is it?
My lords, reportable judgment, my lords, I have not paginated it. I'll refer to the judgment, my lords. Because two questions fell for consideration of the Honorable Supreme Court. The pagination at the, my lords, foot of the page, right side, my lord, page 2 of 76, my lord.
Page?
2 of 76, my lord, judgment, my lords. The pagination is at the foot of the page, my lord. Lords, page number 2, first, my lords, whether the secured creditors, I'm able to point out, my lord.
Yes. Yes.
Please, ma'am. Whether the secured creditors would have priority of interest over the assets attached under the provisions of Prevention of Money Laundering and Maharashtra Protection of Investors of Depositors Act 1999 by virtue of provisions of SURFACE Act 2002 and RDB. Plus, the question that fell for consideration was vis-a-vis SURFACE and MPID.
What is the next one? Whether the provisions of the
Whether the
properties
of the judgment debtors and garnishes attached under the provisions of MPID Act would be available for the execution of the decrees against judgment debtors in view of the provision of moratorium under 14 of the IBC. So the two questions, Lord. One, whether the provisions of SURFACE would prevail over the provisions of MPID or otherwise. The second preposition that Lordship's Lord considered was whether the provisions of MPID will prevail over the provisions of IBC, which is at another central enactment or otherwise. But there's a discussion, elaborate discussion on that point, my lords. My lords, may kindly take my lords. Page number 70 of the judgment, my lord.
Yes.
Now, after detailed and comprehensive consideration, their lordships, my lord, and this is judgment dated 15th of May 2025. My lords, may kindly take my
that
lords.
view of the matter, it is held that no priority of interest can be claimed by the secured creditors against the properties attached under the MPID Act, and the provisions of the MPID Act would override any claim for priority of interest by the secured creditors in respect of the properties which have been attached under the MPID Act. What is the discussion part? Which paragraph?
Please, my lord. Lord, 43, my lords, will kindly take my lord, and then I'll take my lords to the other discussion, my lord. 43, at page number 69, my lords. In the instant case, the attachment of the properties over which the secured creditors is said to have security interest have been attached under section 4 of the MPID Act. Such properties are believed to have been acquired by the financial establishment, that is so and so, either in its own name or in the name of other persons from out of the deposits collected by the financial establishment. All such properties and assets of the financial establishment and the persons mentioned in the said provision vest in the competent authority appointed by the government pending further orders to the designate court. Such monies or deposits of depositors, investors who have been allegedly defrauded by the financial establishment and for the recovery of which the MPID Act has been enacted could not be said to be a debt contemplated under section 26E of the SURFACE Act, and hence the provisions of section 26E could not be said to have been attracted to the facts of the case. The sum substance, my lord, is in paragraph 43 and 44.
Let's take the act.
Please, my lord.
Surface Act. If you look at this,
please.
It is like confined to the case in the facts and circumstances of the case. That's what the court said.
And apart from that, my lord.
To the facts of the case. Let's see what is section
Please.
26E.
Please, my lord.
So this judgment, the Honorable Apex Court has not said that this 26E will not apply when it comes to the MPID Act. The court said in the facts and circumstances.
Please.
That's it. So we cannot take it as a.
If I'm able to establish.
Yes.
But if I'm able to establish two things, my lord. One, that the section that fell for consideration before the Honorable Supreme Court of MPID and of SURFACE, well, SURFACE would be the same, my lords. If I'm able to prima facie establish.
So for that, we need to see some other paragraph. This paragraph, there is no such. Let's see the exact discussion on this and how they have dealt with this 26E.
Please, my lord. Would my lord permit me to refer from para 3 itself, my lord, because para 3, my lords.
Yes,
page
let's
number
read.
3, my lord, the entire facts have been recorded. Para 3, my lords.
I think we'll continue. It takes time after lunch.
Please.
I'll take up other matters.
Please.
Yes. Pass out.
Great.
Yes,
Because
next.
this issue, my lord, in respect of KPID, this honorable court, my lord, considered earlier occasion that judgment, my lord, I'll point out.
Because it may be of academic
no,
importance
in
for
fact-
this reason.
no, no,
For
no.
this reason, that even the largest bench of my lord's court may not be able to, my lords, prevail over the judgment of the
saying
Honorable
that.
Supreme
No,
Court.
but we will be able to say what is the, ultimately we have to understand what is the ratio that is laid down.
Please, Lord.
But if it is in the facts and circumstances of the case,
Please, Lord.
we can as well say that's not the ratio laid down.
Please, Lord. I'll be able
Very
to
well.
point out.
Yes.
My situation is that I'm the option purchaser. I paid 7
Connected.
crore consideration. They have the possession, they have the money. I have none for about 2 years.
We'll see.
Connected.
Still number 4, Rudra Bhushan.
We'll not take it up at 2:30. We'll take the matter around 3:30 so that I'll be able to finish the other list.
Please.
Yes, 4.
Still number 4,
Yes, 4.
Rudra Bhushan.
Any interim order in this? You have an interim order? You appear for?
For respondent, ma'am.
For the,
KV Lokesh,
which is the bank?
Canara Bank.
Canara Bank, my lords.
Oh.
My lords, this is the essay order which I have challenged before this court, my lords. Page number 19 may be looked into, my lords.
Page number 9.
19. That's the impugned order, my lords.
What is the order?
My lords, I'll just state few dates for the relevance of this court, my lords.
No, let's look at the operative position of the order. What is?
My lords, it is dismissed. The essay is
So
dismissed.
the delay of 5 days in presenting essay.
Yes. I'll just point out only 3 dates, my lords. 15/6/2023.
15/6?
2023, section 14 order is obtained by the respondent bank. And section 14 order is administrative order that is passed without the presence of the borrower. My lords, I come to know about the order on 2/8/2023 and which has been stated before the Honorable DRT. And the Honorable DRT has mentioned it in para number 2 of the impugned order. My lords, the case, I may read, my lords. The case set out by the petitioners / applicants through the notary attested affidavit by the first petitioner, first applicant accompanying the IN brief is as follows. The petitioner came to have knowledge of the impugned order dated 15/6/2023 only when the vacation notice dated 2/8/2023 was affixed on the schedule immobile property. The online copy of the order was also received on 3/8/2023. Hence, from the date of knowledge, there is no delay. My lords, now the section for the limitation for challenging the section 14 order is 45 days. And I come to know about the section 14 order on 2/8/2023. My lords,
Let's
on
see the
fir-
section.
My lords?
Let's see the section
Yes.
on limitation. Yes.
My lords, on 15/8/2023, I have filed the essay.
On 15,
8/2023.
according to you, within 13 days, you went to the DRT.
Exactly, exactly. The,
Let's see the provision.
My lords, it may be passed over, my lords. I will.
Yes. Next.
Seal number 5, Vijay Raj.
My lords, in this case, the petitioner is not there in the position of the property, my lords. He is not there in the position of the property. And at page number 16, I would like to take your attention, your lordship. At page number 16, I produced.
What is the order impugned?
The case has been filed against the petitioner. OA has been filed by the bank, respondent bank. That is the respondent number 5, my lords. Because this particular writ petition was filed in context to not following the guidelines given by the RBI, Reserve Bank of India. And the two cases have been filed. One is under NA Act, one more under the Recovery under Surface Act. OA has been filed against the petitioner. Now my submission before the Honorable Court is, there was an understanding, like there was a buyback arrangement between the petitioner and the builder. As per the said buyback arrangement, he has already, the builder has repaid the money to the petitioner, and in lieu of that, the agreement has been cancelled. And there is a tripartite arrangement between the bank and the buyer.
Where is the impugned order? That's what.
And annexure L, my lords.
Let's go to that first. Page number. Annexure L is?
Annexure L is the case that has been filed by the
Reserve
respondent
Bank of India.
That because there is no order or anything as only the proceedings have been initiated against the petitioner, my lords. There is no order because we are not there in the possession of the property. My humble submission before the honorable.
Something should be there. Just like that, how can you come to the court without an impugned order?
No, my lords, the order has been the notice has been issued.
Where is that? At least
annexure L, my lords.
Annexure L.
Annexure.
It is not annexure L. It is something else. Annexure L is some guidelines by the RBI.
Guidelines. Annexure J. One second. I'll just go to the synopsis.
So just like that.
Annexure K, my lords. Annexure K, page number 153.
153.
153, my lords. Because the case itself is not maintainable against the petition, my lord. That's my submission. I am not there in the position of the property. That's my first contention. And there is an email correspondence that has been given by the petitioner to the respondent.
Let's see how they have numbered this petition. Let us see the prayer. What is the prayer you saw?
Interim prayer. Prayer. May I read, madam? Page number 35, madam.
Page 35.
35.
To issue a writ of mandamus
against the respondent number 5 and 6
to take coercive steps against respondent number 7 for the recovery of the home loan account of the petitioner and not to take any precipitative action against the petitioner and the provisions of the
NA Act and Surface Act. As annexure J and annexure K.
And interim prayer is? We will now give a direction to the bank not to take any precipitative steps.
Not to take precipitative steps. That is my main contention, my lords. And if you can go to page number 16, my lords, I have reproduced the content of the tripartite agreement. Page number 16 of my
All this we will consider now. All this will be considered in the writ petition with this kind of prayer.
No, my lords, because if there is any public funds, if the public funds has been misutilized by the bank, then the scope is there for the High Court to intervene under Article 226.
Where is that? Where is the action by the bank?
No, action is what they have filed already under NA Act as well as Surface Act against me, my lords. As of now, it is under notice.
If a complaint is filed under the NI Act, your remedy is somewhere else.
No, that criminal.
What is initiated under Surface Act that I want to see? Show me one piece of paper.
Surface Act they have initiated.
Where is that?
That is the OA which has been filed. I have given the downloaded copy, my lords. Downloaded copy has been produced before the Honorable Court. Still, I have not yet to receive the notice by us.
You have come to this court.
No, my lords, because this I filed under GM RES, my lords. Because this case is against the guideline which has not been followed.
I'll dismiss it with cause. Either you withdraw this petition or I'll dismiss this petition with cause for coming to this court.
No, my lords.
Kind of prayers.
My lords, I have a judgment.
Please pass on the judgment.
I have a judgment.
I will consider the judgment and then pass order. Yes.
No, my lords, judgment in this is the same. One second, I'll give that.
Yes.
One second.
Yes.
My lords, one second. Yes.
Already copies.
Copies. In the Modi Saxena Union of India, passed by the concurrent bill, my lords. I would like to take your attention at page number 63, my lords, of the judgment. In the event the borrower cancels his allotment, booking, allocation of the said property, or in the event of PNBHFL cancelling his allotment, allocation of said flat.
Please show one judgment of the Supreme Court which says that in these kind of matters, the High Court will interfere under Article 226, not the judgment. Please come up with a judgment of the Supreme Court. list this matter on 3rd of November at the request of Land Council Petition.
6 urgent, 7.
Much or much.
Sridhar K.
Yes.
Petitioner, my lord. Respondent. The petitioners have taken a housing loan from a private financial company. And the 16 lakhs they have taken, they have already paid about 28 lakhs. Still, they have not given the account. That's one aspect. The other one is, my lord, for this respondent financial private company, the notification has been issued by the central government. Under that Annexure E, this is ousted from applicability of Surface Act. Because under the Annexure E, if the amount, principal amount is 1 crore and above, then only that company can initiate a Surface Act. For this argument, my lord, my learned friend has produced two notification which are in the records, my lord. One is dated 24th February 2020. This 1 crore has been reduced to 50 lakhs. And another notification dated 12th February 2021. Again, 50 lakhs has been reduced to 20 lakhs. Now kindly see Annexure D, my lord. Annexure D, page number 15.
Page number?
15. Annexure D. The last but one column, my lord. Principal outstanding amount 12,95,858. So therefore, even that latest notification also is not applicable for this housing loan. They have taken a annexure.
But the latest notification is
20
on
lakhs.
20 lakhs.
20 lakhs.
But
It
the
is secured
amount is-
interest, Miller, not principal. It is secured interest. It is in total. It has to
What
be
is
what?
outstanding as of now?
As of today, my lord, as of 30 November, September 25, it is 23 lakhs 47,389.
23 lakhs?
47,389.
If he pays 4 lakhs, he'll be out of securitization act.
Please,
Huh? Isn't it?
please.
I'll pay that
Oh, my
4
lord,
lakhs.
that-
That is one aspect. My lord, my friend may not be correct because Annexure E notification says principal amount.
See, that notification.
Annexure E, kindly see, my lord. Annexure E, these are the, in exercise of powers conferred under subclause so and so and so, Reserve Bank of India.
Then, filed by you or filed by him?
Annexure E filed by me.
Page number?
Page number 16, 16. Hereby directs that the public interest to all provisions of the said Act, Surface Act, shall apply to such financial institution with the exception that the provisions so and so shall apply only to such a security interest which is obtained for securing repayment of secured debt with the principal amount of rupees 1 crore and above. If the principal amount 1 crore and above,
What are the notifications produced by him?
now produced by them, this notification is modified in 2020.
Please give that.
That is already they have furnished in the court, my lord. 2020 notification in modification of this. ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು
Memo ಜೊತೆ ಇದೆ.
Memo dated?
ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಸುಮ್ಮನೆ just they have handed out. I can give it a copy.
Please give.
In modification of Annexure E, 2020 came.
Let's see.
Again modification of 2020, 21 came. There is a reference to Annexure E in 2020.
It speaks about the principal amount.
Please, my lord, and subsequent notification on 24th February 2022, it has been modified as say, is read as having assets worth rupees 100 crore and above which shall be entitled for enforcement of security interest in secured debts of rupees 50 lakhs and above as
That's what
financial
50
issue.
lakhs is reduced to 20 lakhs.
Not principal word has been modified, my lord. It is
No, no.
secured debt, my lord. Entire principal plus interest.
No, no.
That will be,
Principal, the main notification says something.
please,
Unless and until that is amended,
Ah.
that remains to be there.
Remains.
Principal.
please, my lord, it is amended, my lord.
Where is that? Where-
Amen.
It only speaks
24th
about, it
February
only speaks
2000.
about the amount.
No, my lord, entirety is been modified. The entire para, the same having.
Let's see.
The word 1 crore substituted 50
Shall
lakhs.
be entitled for enforcement of security interest in secured debts. The word principal is
Having assets worth rupees 100 crore and above, which shall be entitled for enforcement of security interest in secured debts.
debts in total, principal and interest only.
Where,
Has to be read like
where
that.
did it say principal and interest?
Not secured debt
Illa.
of rupees 50 lakhs. This is what it reads.
Annexure E is modified.
And subsequently in 2021, only the amount part after the
What is the
pandemic.
principal amount of yours?
No, my lord, they have not given any statement. Even otherwise also.
Principal amount. which you
12
have
lakh,
allocated.
12 lakh. 12
Ah.
lakhs, 12 lakh, 95,000. My lord, even otherwise also I am ready to settle the matter with this.
What is outstanding as of now?
As
Ah,
on,
let-
as
let them
on
give-
September
24 lakhs.
30. Please.
Let them give a statement. I will also, I am ready to
They can
settle
approach,
the
they can
dispute.
approach the
I
respondent
don't want to
anytime and
continue
make
litigation.
And request, my lord. It can regularize also. If there,
I-
the term is still there.
I don't want to.
And counsel, but the petition submits that the principal amount that is borrowed is 12 lakhs. And in view of the notification dated, what is this date?
Annexure E is
5th
first
August
notification.
2016. 2016. The provisions of the Securitization Act are not involved or not, cannot be invoked. And counsel for the respondent submits that with interest, no, the amount is 24 lakhs. And as such, the bank can invoke the jurisdiction, can invoke the provisions of the Surface Act. Then counsel for the petitioner submits that he is ready to pay the amount, but the bank is not coming out what is exactly the outstanding. The petitioner shall approach the bank by 3rd of November, and the bank shall furnish all the details. And by the next date of hearing, petitioner shall come up before the court. What is the mode of payment? This is matter on 11th of November.
My lord, I may make request, my lord, one submission. Let them not precipitate the matter till then, my
Each
lord.
time let the bank, there shall be direction to the respondent not to precipitate the matter, not to take any coercive steps.
Number 8, Matavita.
Yes.
My lord, section 14 order is challenged, my lord. Section 14 order is challenged. The outstanding balance is 44 lakh 93,000, my lord. This is a loan.
No, unless
Taken.
we hear the other side, we cannot pass any order. Unless you show what is the glaring irregularity.
My lord, in this, it's a loan taken by the trust, my lord. 1.5 crores.
Who appears? Union Bank of India. Divya? Her name is there. So it's not. 8, where is the name of Divya? So and so is directed to take notice on behalf of the bank. Print the name of so and so. This is matter on 6th of November. Yes, next.
Number 9. Are we Srinivas Reddy?
Respondent, my lord.
Yes.
The petitioner, my lord.
Yes.
My
Lordship
lord,
had
I have
directed them to
intimated the
when they'll be
parties,
paying
my lord,
principal amount, my
regarding
lord, today.
payment of principal amount. They're seeking 1 week time, my lord. So kindly grant, my lord.
Payment to the principal amount pending disposal of the
The lordship was the view that if they pay the principal amount, you will allow the writ appeal for adjudication of balance amount. That's what the Your Lordship had directed them.
So then that, with that, we'll make a final order.
Obliged.
A week's time.
A week's time in
Yes.
filing the
We'll pass orders after that.
obliged.
Number 11.
We'll continue. Oh, one more matter. Yes.
Kanna?
Yes, sir. What
Pass
about?
out.
Pass it.
Please.
Yes.
Your Honor, requesting a memo for posting, please.
Not at this time.
My Lord, my presence will be dispensed with, my Lord.
Huh? Yes, I'll pass order.
Nine pass out. 11 1 week ಅಲ್ಲ, 9 ಏನಾದ್ರು?
ಸರ್ ಸರ್ ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟ್ರಸ್ 2:30ಗೆ ಕರಿತೀರಾ ಲಿಟಲ್
ಮೇಡಮ್ ಹೇಳ್ತಾರೆ ಬರ್ತಾರೆ. 9 ಯಾರು? ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ.
ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತಾರಲ್ಲ.
ತಿರುಗಿ ಕರ್ದೇ ಇಲ್ಲಲ್ಲ ಇನ್ನ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಮಧ್ಯಾಹ್ನ
ಯಾರು? ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ. ಹೂ ಇದೆ. ಲಿಸ್ಟ್ ನಂಬರ್ 3 ತಾನೆ? ಹೂ ಇದೆ. ಮೆಮೊ ಫಾರ್ ಮಾರ್ನಿಂಗ್, ಟುಮಾರೋ ಮಾರ್ನಿಂಗ್. ಆಲ್ರೆಡಿ ಸೆಂಟ್ ಟು ಚೇಂಬರ್ ಮಾರ್ನಿಂಗ್ ಇಟ್ ಸೆಲ್ಫ್. ಆ ಕಡೆ ಇದೆ ಬನ್ನಿ. ಇಷ್ಟು ಸೀಲ್ ನಂಬರ್ 10 ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ. ಮೈನ್ ಪಾಸ್ ಓವರ್ ನೀವೆಲ್ಲ ಪಾಸ್ ಓವರ್ ಅಂದ್ರಲ್ವಾ? ಮಂಜು ಊಟ ಮಾಡ್ಕೊಂಬಿಡಿ, ಮೇಡಮ್ ಸಿಟ್ಟಿಂಗ್ ಅಲ್ಲಿ ಇದ್ರು, ರಿಸೀವ್ ಮಾಡಕ್ ಆಗಲಿಲ್ಲ. ನೈನ್ ಯಾವ್ದಮ್ಮ ಸೀರಿಯಲ್ ಫೈಲ್ ಎಲ್ಲ ಫೈಲ್ ಇದೆ. ಇಷ್ಟ ಅಲ್ಲ ಇದು ಎಸಿ ಆಫ್ ಮಾಡ್ಲಾ? ಬ್ರಾಂಚ್ ಕೊಟ್ಬಿಡು, ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ. ಮೇಲೊಂದು ಫೈಲ್ ಐತೆ, ಇಲ್ಲೊಂದು ಐತೆ. ಸೇಮ್ ಜಯಂತ್
ಇಷ್ಟೇನಾ?
ರೆಡ್ಡಿಂಗ್ ಎಲ್ಲ ಪಾಸ್ ಕೊಟ್ಬಿಡೋದು ಅಷ್ಟೇ.
ಇಷ್ಟೇನಾ?
ಇಷ್ಟ ಆಯ್ತದೆ ಎಲ್ಲ ಪಾಸ್ ಅವ್ರು ಆಗ್ಬಿಟ್ಟವು. ನಾವು ಫಾಸ್ಟ್ ಆಗಿ ಹೊರಟೋಗ್ತಾರೆ ಅವೆಲ್ಲ 1 ಗಂಟೆ ಮುಗಿಸ್ 4ನೇ ಲಿಸ್ಟ್ 1ನೇ ಅವರ್ ಮುಗಿಸ್ಬಿಟ್ಟು.
ಹೌದಾ?
ಫಾಸ್ಟ್ ತುಂಬಾ ಫಾಸ್ಟ್ ಅವು ನಿನ್ನೆ ಕೇಳ್ಬಿಟ್ಟು ಬಂದ್ಬಿಟ್ರೆ ಫಾಸ್ಟ್ ಹೊರಟ. ಅಲ್ಲೇ ಇಟ್ಕೊಂಡು ಅವರು ಗಣೇಶನ್ ಗಡ್ಡ ಆಗೋಯ್ತಲ್ಲ ಏನೋ ಇಟ್ಕೊಂಡವ್ರು ಬಿಡು ಅಲ್ಲೇ.
Thank you.
5 PM ಚೇಂಬರ್ ಕೊಟ್ರ ಅಲ್ಲಿ 5 PM
ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅವರು ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ ಇಲ್ಲ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡು ಸರ್ ದಯವಿಟ್ಟು ಕಳಿಸಿದ್ದೀವಿ ಅಲ್ಲ ಸರ್
ಅವರ ಅಪ್ಲಿಕೇಶನ್
ಫಸ್ಟ್ ಇಲ್ಲಿ ಚೆನ್ನಪ್ಪ ಬರ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂದ್ಮೇಲೆ ಕನ್ಫರ್ಮ್ ಹೊಸ ಅವ್ರು ಕರೀತಾರೆ ಮೋಸ್ಟ್ಲಿ
ಫಸ್ಟ್ ಪಾಸ್ ಓವರ್
ಸಾಮಾನ್ಯ ಪಾಸ್ ಅವರ ಕರೆಯೋದು. ಅದು ಇದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅಲ್ಲ ಅವ್ರು ಯಾರು ಕೇಳಿದ್ರಲ್ಲ ನೀವು ಇದೆ ಅಂತ ಹೇಳಿದ್ರಂತಲ್ಲ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 4 December 25 in the month of December 25 but just urgent ಮಾಡ್ಬಿಟ್ಟು in the month of December 25 ಯಾರು ಇಲ್ಲ ಇಲ್ಲ ಇಸ್ತ್ರಿ ಇದ್ರಲ್ಲಿ ಯಾವ್ದು ಅರ್ಜೆಂಟ್ ಕರಿಬೇಡಿ ಪ್ರೊಸೆಸ್ ಎಲ್ಲ ಕರೆದಿಲ್ಲ. ಮಕ್ಕಳೆಲ್ಲ ಏನಾಗ್ತಾ ಇದ್ದಾರೆ? ದೊಡ್ಡವರಿಬ್ರು ಹೆಣ್ಮಕ್ಳ ಕೊನೆಯ ಮಗ ಎಷ್ಟಿನ್ನ 15 ಜಾಸ್ತಿ ಮೇಲೆ ಇದೆಯಾ ಸರ್ವಿಸ್ 41 ಮೆರಿಟ್ ಏನಾಗಲ್ಲ ತಗೊಳ್ಳಿ ನೀವು ಯಾರಾಗಿರ್ತೀರ. ಗೆ 30 ಇಂದ 35 ಜಾಸ್ತಿ ರಿಟೈರ್ಮೆಂಟ್ ಇದೆ. ಮಾಡೋದಿಲ್ಲ ನಮ್ಮ ಬ್ಯಾಚ್ ಎಲ್ಲ ಹೊರಟೋಗ್ತೀವಿ. ಆಮೇಲೆ ನೀವೇ ಎಲ್ಲ ಹೈಕೋರ್ಟ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ DR ಎಲ್ಲ ನೀವೇನೆ. ಮೂವತ್ತರಿಂದ 35 ಜಾಸ್ತಿ ರಿಟೈರ್. ಚೆನ್ನಪ್ಪ ಚೇಂಬರ್ ಫೈಲ್ ಕೊಟ್ಟ ಒಂದು ಮ್ಯಾಲಿಟ್ಟಿದ್ವಲ್ಲ ಅದು ಚೇಂಬರ್ ಕೊಟ್ಟ ಕೇಳ್ಕೊಟ್ಬಿಟ್ಟ ಹೇಳ್ಬಿಟ್ಟು ಕೊಟ್ಟ
ವರ್ಕ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಆಗೋಗ್ಬಿಡುತ್ತೆ 1 ಅವರ್ ನಿಮ್ಗೆ ಅಪ್ಡೇಟ್ ಮಾಡಕ್ಕೆ ಲೇಟ್ ಆಗ್ಬಿಡುತ್ತೆ. ಅದು ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ರೆ ಡಿಲೇ ಕಂಡ್ರೆ ಅಂದ್ರೆ ಇಂಡಿವಿಜುವಲ್ ಆಗಿ ಹೋಗಿ ಅಪ್ಡೇಟ್ ಮಾಡಿ ಬಲ್ಕಲ್ ಮಾಡಕ್ಕೆ ಯಾರು ನಮ್ಮೂರ ಹತ್ರ ಇದಾರೆ ನೀವು ಇದ್ದಾಗಿದ್ರಲ್ಲ. ಇದಾರೆ ಅವ್ರ ಮನೆಯವ್ರ ಮೊನ್ನೆ ಫೋನ್ ಮಾಡಿದ್ರು, ಅದೇನೋ ಸೈನ್ ಹಾಕಕ್ ಆಗ್ತಾ ಇಲ್ಲ ನಮ್ಮ ಮನೆಯವ್ರ ಕೈಲಿ, ಬ್ಯಾಂಕಲ್ಲಿ ಚೆಕ್ ಹಾಕಿ ತಗೊಳಕ್ಕೆ ಏನ್ ಮಾಡೋದು, ತಂಬ್ ಇಂಪ್ರೆಷನ್ ATM ಕಾರ್ಡ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಅಂತ ಅವ್ರೆ. ಸೈನ್ ಕೈ ನಡಕ್ತದ ನೀ ಇದ್ದಿದ್ ಮನೇಲಿ ಕಳ್ತನ ಆಗ್ಬಿಡ್ತು ನೀವು ಹೋದ್ಮೇಲೆ. ಪಕ್ಕದ ಮನೆ ತಾನೇ ಇದ್ದಿದ್ ನೀವು, ನಾನ್ ಮೇಲಿದ್ದೆ. ಅದೇನಾಯ್ತು, ಯಾರೋ ಡೆಲಿವರಿಗೆ ಹೋಗಿದ್ರಂತೆ ಪ್ರೆಗ್ನೆಂಟ್, ಸುಮ್ನೆ ತಂದಲ್ಲಿ ಹಾಕಿದ್ರು ಐಟಮ್ಸ್ ಎಲ್ಲ ತಂದಾಕಿ 5 ಮನೆ ಕಳ್ತನ ಆಗಿತ್ತು ಒಂದೇ ದಿನ. ಎಲ್ಲಿ ಸಿಗ್ತಾರೆ ಮೇಲೆ ಗ್ರಿಲ್ ಹಾಕ್ಸ್ಬಿಟ್ರು ಸುತ್ತಲೂ, ಇಂಡಿವಿಜುವಲ್ ಸಪ್ರೇಟ್ ಗ್ರಿಲ್ ಹಾಕ್ಸಿ ಸಪ್ರೇಟ್ ಬೀಗ ಹಾಕಂಗ್ ಮಾಡೋದು PWD ಗೆ ಹೇಳಿ. ಆಮೇಲೆ ಅದಕ್ಕೆ ಹೋಯ್ತು, ಆಮೇಲೆ ಅಂಗಡಿಲಿ ಕಳ್ತನ ಮಾಡೋದು, ಕೆಳಗಡೆ ಇತ್ತಲ್ಲ ಶೆಟ್ರು. ಇದು ಲೋಕಲ್ ರೆಕಾರ್ಡಿಂಗ್ ಅಂತ ಇದು ಲೋಕಲ್ ರೆಕಾರ್ಡ್ ಆಗುತ್ತೆ ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿ ರೆಕಾರ್ಡ್ ಆಗಿರ್ತದೆ ಅವೆಲ್ಲ ಮೇನ್ ಇರ್ಬೇಕು ನಾವ್ ಏನ್ ಮಾತಾಡೋದು ರೆಕಾರ್ಡ್ ಆಗ್ಬಿಡುತ್ತೆ என்ன
Lordship, kind leave, Your Lordship. I sincerely apologize. In the morning session, I had to attend a funeral. I could not be present in the serial number 14, Your Lordship. I had made an arrangement, a colleague of mine to represent. In fact, Your Lordship, on the other side, I had made a wrong submission that we have not complied. We have served and we have complied and we have served the copy to them.
No, I
and
didn't say
acknowledged.
anything. If it is not, it will, that's its submission.
Huh.
Interim order is it's a conditional order. If you
We have
not,
complied or not.
I have not, I said, it's a conditional order. If it is not complied with, he's always at liberty. If
It
you
is
have complaint,
extension. That is what my only grievance was, that she said the interim order was not extended.
she didn't ask for it.
I sincerely apologize.
It's not
And in fact, I conveyed.
Yes, it is.
Serial number 14, Your Lordship.
WP number?
WP number 24575.
But it is a different case, I think. In this,
No.
it is interim order is extended.
24575. That's what, because I was not present.
Yes,
with
it is extended.
And I have complied the order also. Grateful.
Password, except that password, all other passwords you call.
List list number 1, serial number 12. Abhilash.
Appear for the petitioner, wife in this case.
So the respondent, my lord. My lord, before the petitioner council makes a submission, my lords, there were missing pages, around 20 pages which were missing, my lord. There were 20 pages which were missing, and that led to a differentiation in the page numbers. We've been served a copy of the 20 pages. We have filed a statement of objections on the same, but we have not gone through the 20
This is
pages.
matter on Saturday.
Please, my lord.
Yes, next.
Interim order may kindly be extended.
Interim order.
My lord, if I may, please, can it be listed on 28th or 29th of the coming week?
Yes.
Please, my lord.
Yes.
List number 2, serial number 4. Rudra Bhushan.
That's for the petitioner in this case. That's morning I had to point out the provision in which the limitation is prescribed. 17(1), my lords. Section 17(1). I may read, my lords. Surface yet.
Yes.
Any person, including borrower, aggrieved by any measures referred to in subsection 4 of section 13 taken by the secured creditor or his authorized officer under his chapter may make an application along with such fee as prescribed, as may be prescribed to the debt recovery tribunal having jurisdiction in the matter within 45 days from the date of which such measure had been taken. My lords, in this case, as pointed out in the morning, my lords, 15/6/2023 was the section 14 order, and section 14 order is passed without the presence of the borrower or the guarantors. And the vacation notice admittedly is issued on 2/8/2023. And on 15/8, we have filed the essay. So hence there is no delay. That's my contention, my lords. My lords, page number 22 of my writ petition may be looked into. 22.
Yes.
That's page number 22 of my writ petition.
Yes.
My lords, this is the finding of the Honorable Tribunal. According to the petitioners applicants, they came to the knowledge of the impugned order on 15/6/2023 only when the vacation notice dated 2/8/2023
Where
was.
is that order in the 14?
My lords, I have not annexed that order. My lords, I have not annexed it, but it may be posted on next week or Tuesday. I will get the.
I appear for the
Lords, I
respondent.
have
I appear for.
Lords, my colleague will pass on one copy of one order copy, my lords, in
Yes.
very same situation, very same borrower, very same bank, where this court has directed them, relegated them before DRT. Similar such order may be kindly passed, my lords. Same relief is sought. The petitioner in the WP number 27296, which the order which I passed on to your lordships. The
Can I
second
make some?
petitioner is the petitioner appellant here, petitioner here.
My lords,
Alternative remedy is very much available, my
can I
lords.
make
Let them
only one
let them
submission?
go before
This
DRT.
is with regard to other immobile property.
No, the only, it's a legal issue.
Yes.
The issue is whether the appeal that is filed before the DRT after 45 days, and according to him, within 13 days from his knowledge, is maintainable or not?
Milords, last date of hearing, Milords, I think my Leonard friend, he told within 2 months he's going to close the loan account. That's what his submission was on the last date
No,
of hearing.
I pass orders on the merits of it. Will not go into
Yes,
any of these aspects.
yes,
So
Milords,
please tell the court.
interim order is operating, Milords. He is not coming forward to make payment, make settlement, nothing, Milords.
No, please understand, please tell the court. No, I mean, whether the order of the DRT is sustainable or not.
Well, order of the DRT is appealable under section 18 of Surface Act, Milords. Let him raise all these grounds before. Lordship may kindly for a moment look to the order what I have provided to
You're
your
not
Lordships.
understanding one thing. First of all, right from 2024, this writ petition is entertained, interim order is granted, he is enjoying it. What is the purpose of relegating now? It's a simple issue. Whether that 45 days notice is from the date of knowledge, if according to you, whether he has knowledge even before that order is passed, is the only issue. If not, DRT will decide under 13(4), I mean, legality of the proceedings under 14.
Section 17.
Lords, the petition itself is not maintainable. Only on the ground already. Lords, he has an alternative. That's what in his very own case it is decided by this honorable court. How can it be
Then why
different
did you
for
keep
him,
quiet when an interim order is granted in this?
Milords?
Why did you keep quiet when an interim order is
No,
granted?
that was expert interim order,
No, what
Milords. That
is
was expert.
happening is, in fact, by this submission, that is useful for him now. That is in his favor now. Happily he
filed my
enjoyed interim order. Now we will go. Now we will grant him protection. Now happily now we will go somewhere else. That's so. Why should we do all
Milords,
this?
he has my very same petitioner, Milords, has availed the alternative remedy on the very same cause of action before DRAT.
That's not the
No,
same.
no, that is not the. No, that is not the
It can't
same.
become different. It can't become different for him in this case exclusively.
Let's see what is the order impugned there. Please read it.
Milords,
Please read the order.
same. Milords, Lordship may kindly come to page 2 of the WP number, the order which I provided to you. Same DRT order was challenged before this court.
No. No.
Yes, sir. The WP is filed under Article 226.
Before the court. I think it's not one and the same.
One short date. Give me a minute.
This is matter on Saturday.
Malats, not Saturday, Malats. Any
Order earlier granted is.
Malats, Monday,
extended
Malats,
than
if possible. Monday.
Saturday.
Yes.
Yes,
Great. Interim order may be extended.
Till number 9.
Grateful.
Yes.
Srinivas Reddy.
Yes. For the petitioner, my lord. My lord, last hearing date, it was, last hearing date.
I remember
was,
that.
Yes, my lord.
Where is the impugned order?
Impugned order. My lord, it's seeking their brother is not well, my lord. They are hospitalized. So they are saying that if 1 week time is granted, they will discuss and let
No
them
discussion.
know, my lord. My lord, please, my lord.
If you are taking an undue advantage of whatever the concession the court is giving, I will dismiss it right now.
No, my lord.
Morning you said 1 week. I'll pass an order. I will pass an order that you have to pay within 1 week.
My lord, kindly have it on 28th, my lord.
Why?
My lord,
And why was this court passing an order on? Why did the court pass on 16th and 2020?
My lord, it's because his brother is not well, my lord. He's been hospitalized and he went to Hyderabad. So, and it's also a very serious condition.
Not a case for any kind of interference by this court.
My lord, I'm really sorry, my lord. Please, my lord, just 1 week, my lord.
This is matter on Saturday. By that time, is specific with regard to the payment. If there are no instructions from the petitioner to the counsel for the petitioner, the petition will be the orders will be passed on the merits of it. Yes, next.
Number 11. Bhimanna.
Yes.
It's a matter, my lords, wherein we, even before the expiry of 90 days, the account was classified as NPA, which cannot be done as per the circular of the RBI, my lords.
What are your instructions?
And we are even ready to settle the loan amount, my lords.
Lordship, I appear for the respondent
Is
today.
it so? What is the submission is correct?
Absolutely not. May I invite Lordship's attention to page number 12. It is a statement produced by them of the bank, produced by them. Since January 2023, though not a single payment has come. Lordship can see on the credit side, it's all 000. Last payment was 7,700 on January 2023.
Your lordship may kindly see at page number 14.
Even, no, I have not finished.
Let him submit.
Even before that, prior to that.
No. You were referring to which date?
16/1/2023. On the credit side, 7,700.
Which page?
It is page number 14, I think, 14.
13.
16/1/2023, I can, yes. That 7,700 is continuing. No payment.
After that, there is not a single payment. That means
So that is from,
whatever contention that he is telling that 90 days without completing 90 days.
let's take it. Let's look at the dates and let us understand what is his contention is. So the last payment was when?
13/12/2023, my lords, at page number 14.
30, no. Page 13, when is the last payment?
Lords, in the page 13, my lords, your lordship may kindly see 17/8/2023, 7,700.
17/8/2023.
Last but 5 lines. Credit side.
7,700 credits every month we are seeing here.
No. Every month he has to pay 7,700.
That you see till when?
That is, Lordship, let me complete. The last, according to me, as per whatever documents he has produced with me, 16/1/2023 is the last payment.
16/1/2023. That we find it where?
It's a 5-page statement. On 16/1/2023 is the last payment, that is 7,700.
Last payment is on 13/12 at page
So thereafter
14.
also you see.
No, whatever payment documents.
And I'm also looking at it. If you look at the credit.
Now, before that, Lordship, how it happens is, whenever 3 installments accumulate, it becomes 90 days. It need not be continuous. Whenever 90 days is 3 installments are not paid, it is calculated as an NPA.
Let's see from there.
Now, even before that, 2023, he has not, the last payment he made before January was somewhere on 10th of 22,
So
October
please-
2022.
No, you have declared his asset as a NPA. According to you, what are the dates where he has defaulted for 90 days?
Yes,
Please give those months.
months. So, "13-2 notice was issued on 21
I'm asking about the NPA.
NPA.
NPA months, which are the months?
Were not paid.
Yes,
November he has not paid of
November.
22.
November 22. Then it should be consecutive. So December 2022, Jan 2022, you must have not paid. I mean, Jan 2023. That 3 months I'm asking.
Yes.
That's a specific contention of the petitioner.
I think my learned friend is confused.
One payment was made on 5/9/22, so that passes. 5/10/22 also one payment was made.
Yes.
So 11 and 12 he has not made any payment.
11 and 12 is only 60 days.
60 days, sir.
Then
It need not be continuous, sir. Now again, after that, February has not paid.
so you can randomly pick up somewhere 30
It is
days.
not like that. It is not like that. If prior 2 installments are not paid, then he pays one. Again, he doesn't pay one. So it is
Where are those
calculate.
guidelines with regard how you declare a account as NPA?
That is, I'll have to take time because income tax.
Take that.
What are you producing?
Master circular by RBI.
Where do you get it?
Let's part A 2.1.2 millards after the index.
1.2, yes. Read. Please read.
Interest, a non-performing asset is a loan or an advance where interest and or installment of principal remains overdue for a period of more than 90 days in respect of a term loan. This is a term loan, minutes. Then comes the account remains out of order as indicated in para 2.2 below in respect of overdraft or cash credit. The bill remains overdue for a period of more than 90 days in the case of bills purchased and discount. Then those things will not apply. 2.1.3 millards. In case on interest payment, bank should classify an account as NPA only if the interest due on charge during any quarter is not serviced fully within 90 days from the end of the quarter. They are saying about the interest. End of the quarter would be December, millards. From that, if we go by circular, it should be 90 days. It should be in the month of April. They classify my account as NPA on 1/2/2024. Even though when I have paid an interest on 13/12/2023, which can be seen from their own statement.
According to you, when was the NPA?
13/12, sir.
NPA declaration?
No, it is for the bank. It is for the bank to say.
1/2/2024. Their affidavit states, my lords.
Where is that?
At page number 25, which they filed before the learned magistrate while filing section 14 application. Page 25, my lords. Column M, 1 to 4th column, my lords. NPA date. Consequent upon the defaults committed by obligors loan account was classified as NPA on 1/2/2024.
So now, in the light of this, we'll look at your account.
Kindly, my lords.
1/2/2024,
my lords.
Three to 2024. Before that, when did you pay?
The last payment is on 13/12/2023, my lords.
13/12/2023.
That is the last payment that I have made.
13/12/2023. Then they have declared it on 24.
1/2/2024.
That's not how it is. Suppose he doesn't pay for 10 months and he pays for 1 month.
No,
So
there
he'll
should
be.
be, no.
Can
There
be
is
clearly seen,
some
my lords.
procedure for that.
No,
We should
absolutely.
know that.
I understand.
At least-
It has to be seen as.
No, from a plain reading of it, it shows that.
No. It is not
consecutively-
like that. It is the first installment which is not paid within 90 days. First installment, pending installment. It is not the last installment. Now, when he doesn't pay in March, November, December 2022.
23, sir.
And then he pays in January. And again, he doesn't pay in February and March 2023. He will be qualified. Just because 1 month in between he has paid doesn't qualify me.
Court has to understand on what norms, on what procedure the bank is,
Absolutely.
This is also,
Absolutely. That's what I am trying to illustrate. Now, the point is, he has not paid for a whole lot of months.
90 days.
Not 90 days. Whole lot of months.
Oh, my lords, that is a wrong submission, my lords. My account statement clearly states.
Now, as per your, the proceedings before the magistrate, you said on 1/2/2024, his account is declared as a NPA. So that means prior to 1/2/24,
I
that is
understand.
1/1, then 1/12, he must have not paid. 1/12 and 1/11 also. Then only you will be.
Lordship, I'll come on that. I will produce a statement stating
And
exactly
also-
on which date he has not
And
paid.
also the guidelines.
Yep, absolutely.
Yes.
Short date may be given.
Learn counsel for the, learn counsel for the, any interim order in this?
No.
Learn counsel for the petitioner submits that contrary to the RBI guidelines, the account of the petitioner is declared as NPA even before the completion of 90 days. Learn counsel for the respondent submits that by following the procedure, they have declared the account as NPA and he will get specific instructions instructions. List this matter on 30th,
Public.
on 30th, till such time, no coercive steps shall be taken.
Kind of, grateful.
Lordship, there is only, we already taken possession of the property. There is no other, we
There
have
is
not
sale,
issued any
Lordship.
notice
They
or
can
anything.
sell the property after advertisement in the paper.
Whatever coercive steps, you should, any other steps you shouldn't take.
Kind of, grateful.
It is submitted by the land council for the bank that they've taken possession, symbolic possession on,
Physical
possession on,
Not on-
they've already taken the physical position, which is not denied by the land council for the petition.
25/9/2025. 25/9/2025.
25/9/2020. Yes, next.
Kind of.
List number 3, serial number 1, Yashwant Somi.
Yes,
Petition, wife petition, my lord, delay in 43 days, my lord.
I
Can
number
answer.
already served on the respondent. I number 1/25 is filed to condone the delay of 43 days. Condoned. Yes.
For hearing.
What is the amount that is granted?
Only
You're seeking
5,000
enhancement.
enhancement, my lord. Only 5,000 is awarded, my lord.
We'll hear it on some day.
Please.
Yes. Saturday?
Up.
Let's just matter on Saturday. Yes, 2.
Serial number 2, Nagaya.
Yes.
I for responding. Your Honor.
Interim order is there in this?
Still it is not come for admission, Your Honor. I for respondent.
Oh, without even notice, you have already filed
I
your.
already
work.
filed wakalati. See.
Then we'll condone the delay.
Think is that 2 years delay is there, Your Honor.
Then you should file your objections if you have filed your wakalat. The counsel for the respondent, no representation for the petitioner. Counsel for the respondent shall file his objections to the I number 1/25 within 2 weeks. List the matter on 19th of November. Yes,
Serial number 3, Prakash Shah.
notice to the respondents. Notice 885 days, we will not.
There is IA pending, my lord.
Let it.
And also, there is FLW, NBW and
It will be
removal
pending.
attachment warrant has been issued.
Why you have not come before the?
I have
court?
already paid 4 lakh rupees, my lord.
Give that. Give the IA under section 5. In that it is there.
I'm the husband, my lord.
That I understand.
No, the one more thing,
Please come to this application, the affidavit. What are the reasons for this delay of 800 and so and so days?
yes,
Yes.
there is no 2 petition filed by my wife. One criminal miscellaneous 211 of 21 on 19th 4 of 21 and one more file MC 2104 of
Where are you reading?
2021, my lord.
Where are you reading? I'm asking
Synopsis,
you to read
synopsis.
your
I'm go through
IA
with synopsis.
under section 5 of the Limitation Act.
Yes.
It is submitted that after service of notice, I appeared and participated in the mediation proceedings. At the time of the mediation, though first respondent agreed for reconciliation,
Yes.
however, she did not join me for the reasons best known to her.
Yes.
I got a job in Hyderabad and hence there is a communication gap between me and my counsel. Is it a ground?
Yes.
Condone the delay
Because,
of 800 days.
yes, I left to Hyderabad. And I haven't communicated with my previous counsel.
Whose problem is that?
Yes, obviously, my lord.
Will not condone 800 days. I can, if you insist, I'll dismiss this IA or else at best notice. Notice to the respondent. Yes,
Serial number 4, Arjun.
yes, please call.
List number 4,
Ready.
serial number 1, Satish Shetty.
Yes,
May I have for dispensation of notice to first respondent, my lord.
I am for respondent.
memo is falsifying dispensation of notice to
Released on next.
R1.
Date pending.
I told you for dispose of, some undertaking should be there from you.
Yes, my lord.
A memo is falsifying dispensation of notice to R1 dispense with at the risk of appellants. Yes,
Kindly list of next week.
why?
I am producing certificate, judgment, some judgments
For what?
for an quantum of appeal, income. Yeah, BA student,
October are taking only 12,500 as per the
We have
chart.
taken in other matter, what is that, Ms. Vijay Kumar, 20,000?
My lord, no, it is a case of injury, not in case of death. It applies to
In that,
case
why
of
he
death.
wants,
He's continued his studies and getting
Third semester.
fit for so
Therefore,
file
my
hearing,
lord,
call for the TCR, yes two.
some
IA
reasonable.
number 1 of 24 is filed to condone the delay of 116 days, condoned on condition. Yes two.
Seal number 2, Syed Abdul Sabur.
Yes.
I am for appellate in this case, my lord. I am filing dispensation.
Huh?
And kindly
On
call
R1.
for records also, my lord, otherwise tomorrow again.
What is that?
R1 notice not needed, my lord, since the liabilities are on R2.
Then where is the memo?
I'll file in the judiciary. The office, my lord.
For this purpose, the matter has to list again. It's unreasonable, Mr. Counsel. List this matter. It is
Morning
submitted
itself.
that R1 is not a, they'll file a memo seeking dispensation of notice to R1. The same shall be done within 1 week, or else the appeal shall stand dismissed against R1. Yes, next. Memo is filed seeking dispensation of notice to R1, dispense with the risk of appellant. Admit post of final hearing, call for the TCR. Yes, 3.
Seal number 3, Vishwanath Pujari.
No more. Not Pujari, no more.
Counsel, what happened to the notice to the respondents? So the appellant is no more, therefore she'll file wakalat to appear for the appellant. Print the name of, in 3, Ms. Prasanna K. List this matter next week. Yes,
Seal number 4,
yes,
Ashok Kumar Shetty.
You have already paid.
wait, he submitted that the needful is done. List this matter of service of notice.
5,
Next 5.
Raghu R.
Memo is filed seeking dispensation of notice to R2 dispensed with. IA number 1 of 24 is filed to condone the delay of 124 days, condoned on condition. It's a case of death or injury.
Injury. Death, my lord.
Death, my lord.
Huh?
Death, my lord.
Where is Geeta?
Geeta Raj. Geeta Raj.
She's here only. Caller, keep this matter aside. Yes, next 6.
My lord, this is.
Number 6, Spurti Hegde.
Yes,
For occurring for the appellants, here to file memo for dispensation.
of notice to R2.
R2.
A memo is filed seeking dispensation of notice to R2 dispensed with. I number 1 of ICICI Lombard.
ICICI Lombard. Pradeep.
Pradeep appears. I see Mr. Pradeep is directed to take notice on behalf of the insurance company. When counsel for the appellant shall serve the copy of the appeal memo. IA 1 of 24 to condone the delay of 71 days. Condoned, admit post for final hearing. Call for the TCR. Next,
7, Benny Ravish.
I'm for filing substitution service application file ಮಾಡ್ತೀನಿ.
you will file.
I paper response.
They submitted that they'll come up with an appropriate application for substitute of service of notice on R2. Does this matter?
R2 last case ಇಲ್ಲ R3 please. All the rest the same respondent.
R2.
First, second,
What is the
third.
name of the respondent, that R2?
Please madam.
Name. If
Owner of the offending vehicle please.
In respect of owner of the offending vehicle, a week's, 10 days time is granted.
2 weeks.
2 weeks time is granted for filing the appropriate application, or else the appeal shall stand dismissed.
My lord, kindly
Yes,
post along with another matters, my lord.
Yes,
Claimants
post
are-
along with so and so. Next 8.
Serial.
Yes, 8.
Seal number 8,
Respondent number 2 my lord.
No representation.
Sakaraja.
No representation for dismissal. Yes, next 9. Dismissal on next week someday, looking at the matter. Yes, Prakash.
Lordship, I have paid the PF this morning, and 500 rupees I have paid, your Lordship. I have deposited the acknowledgement as well. It is not forthcoming.
Why cost? What did you do?
Your Lordship, the last occasion, it was in the previous bench, ma'am had predominantly put the cost on everybody's.
It is submitted that they already processed, already the needful is done. It is submitted that already and cost of rupees 500 is also paid. List this matter after service of note, which is the insurance company?
ICICI Lombard.
Pradeep is directed to take notice
Please,
on
Your
behalf
Lordship.
of the insurance company.
Oblige, Your Lordship.
Yes, sir. You serve the papers on him. Yes, 10. Memo is filed seeking dispensation of notice to R1 dispensed with. I have 1 of 24 to condone the delay of 92 days condone case of death or injury.
Injury, my lord. He's not in station, my lordship. His morning, yes.
Huh?
He is not in station, my
Oh,
lordship.
admit post for final hearing. Call for the DCR. Next 11.
11.
Memo is filed seeking dispensation of notice to R1 dispensed with. I have 1 of 24 to condone the delay of 311 days on condition. Admit post for final hearing. DCR. Next 12.
12. Madhukar Nadi.
Yes.
Appeal memo not furnished to me.
First of all, he's not here.
K. Nagaraj.
Who is R1 and R2?
R1 is owner.
R3.
Liability is on you.
Yeah.
Then why their presence? No
Appeal memo not
representation.
furnished, madam.
Huh?
Appeal memo.
No representation. List this matter for dismissal. 13. List this matter after service of notice. 14.
14. BC Shivanegowda.
The amount, my lord. I'll produce the account. We have deposited in 27.
List this matter after service of notice to R2. Then counsel for the appellant submits that they've already they have already deposited the amount. Yes, next 15.
15. Raja Ramesh.
List after service of notice on R2. 16. This also list after service of notice on R3.
17.
Yes, what about this?
Sri Harsha.
The appellant, my lord, memo for dispensation. For
Of notice
R1.
to?
R1.
R2 is
R2 is the insurance company.
which company?
Oriental.
Oriental Insurance Company. Mr. Ashokan Patel is directed to take notice on behalf of the insurance company. A memo is filed seeking dispensation of notice to
R1. R1, madam.
1 dispensed with, admit post for final hearing, call for the DCR. Next, this is memo of dispensation to R2 dispensed with. IA number 1 of 25 is filed to condone the delay of 563 days, condoned on condition. Next 19.
19.
Memo is filed seeking dispensation of notice to
I appeal for this.
R1, R2, R4 and R5 dispensed with at the risk of appellant. What is this case? Case of death or injury?
Today I have received the appeal memo. Week's time maybe,
Yes,
my lord.
admit
Or
post of
Saturday,
final
it may be have it on.
Any
my
of
lord,
the advocates who are ready with the matters, please tell the court.
Please.
Yes, 20.
I am for appellate in this case. My lord, this case I have already served copy on 23rd, my lord. Acknowledgement is with me, sir, my lord. To
No.
R2.
R2, what happened?
R2 is insurance company. I have sent copy by mail to Sri Shankar Reddy, sir.
Service of notice. Yes, 21. R? Oriental Insurance Company. Mr. Janardhan Reddy is directed to take notice on behalf of the insurance company. Then counsel for the appellant shall serve the copy of the appeal memo on the counsel. Yes, next, 22.
21. Jagdish. Jagdish. HT.
R2 is Kotak General.
R2 is?
Kotak General.
Kotak General Insurance. I think in the list it is not there. Who appears? You appear. Mr. B. C. Sivanagowda is directed to take notice on behalf of the respondent insurance company. Who are the other respondents?
R1 is private man.
The petition shall comply with the other office objections within 1 week or else default order. Yes, next, 22.
22. B. Pradeep. B. Pradeep.
Office objection shall be complied with within 10 days, default order, or else the appeal shall stand dismissed. 23.
23.
Dispensation of notice to R1 dispensed with. Have you served the, where is Mr. Shastri?
Sripad Vishastri.
Where is Mr. Lingaraj?
Just Lingaraj.
There is a cost also here, 300. No representation for dismissal. Yes, next.
I am for appellate in this case, my lord. I have
24.
already
I'm
served
appealing for the
The
respondent
papers
number.
on Mr. Krishna Swamy.
Yes, my lordship.
It is submitted with the
already
papers
done copy.
served on the respondent.
I request for 2 weeks time for the filing
List
local
after
account.
service of notice to R1. Yes,
That's
next.
obvious.
25.
The officer
Vendi
will
Ramesh.
please, for this, kindly take the judgment page number 27, please. Interest to be paid by the owner of the offending, owner of the estate, not by us, please. Liability figure is the owner of the estate. Officer has an objection to be pay the interest. So depart the award
On
amount.
filing of original certificate for having
Produce,
deposited
we have produced, please immediately.
remaining amount of rupees 3,000. Why in your matters only this objection is
I do not-
coming?
No, Lord.
Why the office is against you?
That is an interest to be paid by the owner of the
No, why
estate.
this is so complicated? Why it is not happening in all the
This is the
cases?
third case they are doing, the raising the objection like this, please.
That means there is something wrong.
Nothing wrong. Kindly take the judgment page number 27, please, madam. 2 minutes, please. Already operated for the order. Respond 1 to joint.
What is the calculation done by the office?
Please, madam.
Calculation.
I have to deposit the entire award amount, please. I have deposited.
Total amount to be deposited,
Please.
77,58,026. Amount deposited by the council, 7,54,908.
Please.
Balance is 3,118.
That is an interest, please, madam. Award amount is 6,39,500. I have deposited. It is there, please. I have to pay the interest. I have to pay the award amount only. Interest to be paid by the owner of the offending, owner of the estate. It is there. It is there in the order.
ECA matter.
ECA, please. ECA means estate, please, not motor policy. WC, estate policy.
In that, there won't be, the insurance company is not liable to pay the interest.
The agreement is very simple. Owner has to pay the interest and penalty and medical expenses. That is the agreement between us and the owner of the estate. We have produced the policy copy also.
The office objections are overruled. Yes, notice to the respondent.
I have deposited the entire
Notice to the respondents. The appellant has already deposited the entire amount. They shall be. You are on what ground?
Please, ma'am.
You are on what ground?
Liability, please. Risk of workplace is not covered. Incident took place at the Sringeri. Incident took place in the Kadavati at near Chikmagalur.
Course of employment or workplace?
Course of employment is in that estate, not in our estate, please. Where the insurance policy has taken that he has not employee of this estate.
On, as the entire amount is deposited and the insurance company is on the question of liability, they shall be stay of all further proceedings. Notice to the respondents. Yes.
Stay, please.
Notice.
I said stay. Yes. 26.
26, V. Pradeep.
List after service of notice on R2 and R3.
For the R1 in this matter, my lord.
After service. 27, D. Vijay Kumar.
For the appellant.
Yes.
In fact, I have paid the process.
No, what is this non-filing of proof of deposit?
We have deposited.
You have deposited?
Please,
Then
madam.
counsel for the appellant submits that the amount is already deposited. Yes, 27.
My lord, in this case, my lord, we have paid the process fee on 5/8/2025. But again, for same parties, the court has called for this thing, whether for the first time, what happened to the notice is not forthcoming. Whether the office has noticed this.
This is matter after receiving, it is submitted that the petitioner has already paid the process. This is matter after service of notice.
On 5/8/25.
Yes, next.
28, V. Pradeep.
A week's time default order. Next 29.
29, Janardhan Reddy.
I have to take steps to this, respond number 3, my lordship. There is no DL, my lordship, as on the date of this, so I have to take steps, my lordship.
What is this postal track item delivered to GPO?
As per the track, it is served, my lordship.
It's
Yes.
you find that the registry shall put up the postal track.
My lord,
It's there.
for the respondent number.
You feel what color there on this?
Return means, oh, it is returned.
Returned.
The cover is returned.
That's why I have
The
to take-
petition shall take fresh steps for issuance of
Yeah,
notice to
my lord.
R3 within a week.
And meanwhile, my lordship, I have to, I already, he intimated, within 1 week, I have to deposit, my lordship. 1 week, maybe, granted. Bhadravati, a message in Bhadravati. I have intimated to the company and the Bhadravati branch. Stay
You
complete.
appear for the,
I am for the respondent one, I am filing the wakalat, my lord.
who is respondent number 1?
The owner,
Yes, come.
claimant, my lordship.
Claimant. You are questioning the award,
Pay and recovery is required, my lordship. The tribunal is not awarded the pay and recovery. my
only
lordship.
that much.
Yes, my
Then let them withdraw the money, whatever you deposit. Pay and recover, that's not a problem. Any of court will grant it. What is the amount?
1 minute. 3,79,000.
3 lakh?
3,79,553, my lord.
They deposit the entire amount.
50% is awarded by the compliance of 50% is granted by the time of stay, my lordship.
It's already stay granted. Because in these kind of cases, ultimately you have to pay. You pay and they receive the
madam.
amount. You will also save the interest.
At the time of admission, I have stated before the lordship, I have deposited, but court has granted only 50%. That's why I'm deposited 50%.
If you want, I'll say the order is modified and other 50% also has to be deposited. It's good for you also.
Yes, my lord.
It's good for them. They will get the money. You don't have to pay the interest.
After service, immediately after service of the notice to the respondent number 3, my lordship, we can matter with.
It is submitted that the amount is deposited, 50% amount. On such deposit, as it deposited, the claimant is at liberty to withdraw. List this matter after service of notice to R3 and steps shall be taken within a week or else the appeal shall stand dismissed.
Yes.
Yes, 30.
30.
30, I
Initiation.
appellant, my lords. I have paid the DCF, my lords, today itself.
It is submitted that the needful is
Filing
filed.
dispensation memo for R1.
Memo is filed seeking dispensation of notice to R1 dispensed with.
30.
Yes, next. R2 is Bajaj Allianz. it seems.
Bajaj Allianz, my lords.
You want dispensation of notice to
No,
that?
R1, my lords.
R1
Bajaj Allianz.
memo is, next is Bajaj.
Bajaj Allianz Insurance Company.
HR Renuka is directed to take notice on behalf of the respondent insurance company. Then counsel for the appellant will serve the copy of the appeal memo. Yes. Then notice is complete with this.
Yes.
Service of notice is complete with this.
Yes, my lords, complete.
IA number 1 of 25 is filed to condone the delay of 421 days, condoned on condition.
Please.
Admit. Also final hearing, call for the TCR.
Please.
Yes. Yes.
31. Suresh.
Lord, in this case, my lord, we have filed 2 appeals on behalf of KSRTC. We have filed 2 appeals on behalf of KSRTC. I have given the number, my lord. This
You
matter
filed
will be
with
connected
delay.
with,
You also filed with delay.
that I have to verify. But this
List
delay may
along
be
with so and
controlled.
so. Now what will happen is if you have filed with delay, we'll condone their delay without condition. That's why I'm asking. Yes.
No,
List
ours is
along with
earlier.
so and so on 6th of November. Yes, next 32.
32. Girisha.
Delay of 36 days, my lords.
IA number
The
1
matter
of
may be
24
referred to local adult, my lords.
to condone the delay of 36 days, condone.
Delay, ma'am.
Huh?
We can dispose of matter here itself.
No, my lords. Yeah, no, actually, my lords, I am a proxy counsel, my lords.
Yes.
No problem.
Then counsel submits that the matter may be referred to the Lok Adalat. As registry is directed to place this before the Lok Adalat. Yes, next 33.
33. Dabali.
IA number 1 of 24 is filed to condone the delay of 64 days in filing. Condone. IA number, next matter, MFA 2301, connected matter. IA number 1 of 24 is filed to condone delay of 268 days. Condoned on condition. Next, admit post for final hearing. Call for the TCR. Next 34.
34.
133 days condoned.
Meanwhile, call for TCR, my lord.
Huh?
Meanwhile, call for TCR, my lord.
Yes.
Delay may be condoned 130.
133 days condoned on condition. Admit TCR. Next.
35. B. Chandrasekharaya.
Appear for appellant, my lord.
You will serve the copy. Yes. Land counsel submits that he'll serve the copy and seeks today's time. Let's this matter on 12th of November. Yes, next.
36.
I number 1 of 24 is filed to condone the delay of 41 days.
Copy is not served, my lordship.
Condone. Admit post for final hearing. Land counsel for the appellant shall serve the copy within 1 week on the counsel for the respondent insurance company. Yes.
Oblige, my lordship.
37. Jagdish.
IA number 1 of 25, condone the delay of 12 days, condone, admit for final hearing TCR. 38.
38. H.
Yes.
Banu Prakash.
In active matter, I paid the TCF.
No, what about this? Which respondent is insurance company in this? 38?
Second respondent.
Huh?
Second respondent,
Ah,
R2.
In this, Geeta R is directed to take notice on behalf of respondent number 2. And the liability is on the insurance company.
Yes, yes, my lords. I have.
List MFA 5109 of 2025 for dismissal on Saturday.
Much obliged.
Yes, 39.
As far as the DCF, I paid it, my lords.
In
my
that I'll
appeal.
pass
Yes,
the orders.
yes, my lords.
Yes. Yes, 39.
Copy served, my lord.
39.
May be granted to file.
Copy, sir.
Can you file it? I number 1 of 25 to condone the delay of 78 days. Condone. Admit post for final hearing. Call for the TCR.
Please.
Yes.
40. Nayak Krishna.
Lord, in this case, my lord, owner appeal, my lord. I have challenging the liability, negligence and quantum. My lord, regarding the liability, my lord, the vehicle was at the as on the date of accident, my lord.
What ground the liability is fixed on the
My
owner
lord,
of the
no
vehicle?
permit, my lord. Vehicle is no permit, my lord, as on the date of accident, my lord. And further, my lord, negligence, my lord, the rider of the motorcycle.
Of death.
Case of death, my lord.
How much is the amount granted?
My lord, 7,72,020 rupees, my lord, along with interest, 6% interest, my lord.
Deposit.
50% deposit, my lord.
It is submitted that the liability, the tribunal has fixed a liability on the owner of the vehicle only on the ground that the permit is not there. It is submitted that even in that case also the principle of pay and recover will apply. Considering the submission, they should be stay of all further proceedings on the condition that he shall deposit 50% of the amount within how many days is generally granted? 4 or 6?
6 weeks. 6
Just
weeks.
for the 4 or 6 stay.
6 weeks.
No, I don't want any idealistic situation. I'm asking generally what it is.
Generally, my lordship.
Huh?
6 weeks, my lordship.
6 weeks. Yeah, insurance company 2 weeks.
Madam, for the submission, my lord, 50% deposited amount FD in any nationalized bank, madam. After deposit.
After deposit, you want to
Fixed deposit, my lord.
No, they will withdraw.
Sorry.
50% amount shall be deposited, and on such deposit, the claimants are at liberty to withdraw, then they will pay.
After amendment, the accident, my lord, pay and recovery clause is there, my lord.
That's what they will pay then. They will pay you. Yes. Anyway, what is that you are going to get? Even if ultimately permit is not there, pay and recover will apply. You are only having some time. Court is granting you some time. Nothing else. 50. Ultimately, this appeal will go. If 50% on such amount, they are entitled to recover. They are entitled to withdraw the amount. Which case? In this notice to the respondent. Yes.
Paper for applied.
Dickerson.
I am filing memo for dispensation of notice to R2.
R?
Respondent number 2, madam.
Only 1 and 2 are there.
1 and 2. New India Assurance.
Mr. Shankar Reddy is C is directed to take notice on behalf of the insurance company. A memo is filed seeking dispensation of notice to R1 dispensed with.
R2, madam.
R2 is dispensed with. I number 1 of 25 to condone the delay of 96 days condone. Serve the papers on him.
Please.
Shankar Reddy.
Please.
Yes, next. Yes.
42.
Paper for applied, madam. I am filing a memo to
Same.
same.
This also Shankar Reddy and delay of 51 days condone. Yes, paper shall be served on him. Yes, next.
43. Srinivasaya.
I think for applied R2 Reliance Insurance.
R2 is Reliance. Pradeep is directed to take notice on behalf of the insurance company. And the appellant shall serve the copy of the appeal memo on the council. IA 1025, 55 days condoned, admit goes to final hearing. Huh? R1 is there. Liabilities on whom?
Not disputed.
Huh?
Liability is not disputed,
Then
madam.
dispense with you.
I will file, madam.
Memo is filed seeking dispensation of notice to R1. Dispense with, give it right now.
Please.
Yes, 44.
44.
What about this?
Pavanachandra Shetty.
No representation. List this matter for dismissal. 45.
But appeal by the insurance company, my lord, it's an ex parte judgment. my lord.
727 days.
Connected matter, my lord, your lordship has granted stay on 17/10/25.
Today also I have seen 10 MFAs all pinned up for the stay. Why are you waiting for so many days for those
No,
many
my lord,
matters?
I think 3-4 times I have filed the memo.
No, today I've seen
Yes.
entire,
Yes,
so
yes,
anyhow, all your matters can't be heard today.
No,
So
no.
I've given the matters
My lord,
from,
repeatedly,
no,
my lord.
from tomorrow till 5th of November, I have given every day 1 month. Yes.
Because I have moved many times.
What is the amount granted?
My lord, 1 to 2 lakh.
I number 1025 is filed to condone the delay of 27
2 lakh
days.
34,000.
It is submitted that there is a, the execution proceedings are initiated, as execution proceedings are initiated by the respondent, it would cause of loss of hardship to the appellant. Considering the same, they shall be stay of all further proceedings on the condition that they shall deposit 50% within 6 weeks.
Much of it.
On such deposit, the respondents are at liberty to withdraw. Notice to the respondent. Yes, 46.
46. Shankar Reddy.
Deposited the amount.
Already deposited.
Land counsel for the applicant submits that already amount is deposited in 46.1. Memo is filed seeking dispensation of notice to R1 dispensed with. IA 1024 is filed to condone the delay of 60 days. Condone. Next 47.
Admit. Admit.
What is this? Earlier matters all admit. 47.
GM Srinivas Reddy.
In that which is the insurance company?
R2 is United India.
Mr. S.V. Hegde Mulkand, it is directed to take notice on behalf of the respondent insurance company. Then counsel for the applicant to serve the copy on the counsel. Notice to the respondent, which is that is R1.
R1.
Notice to R1. Yes, 48.
48. G. Ravishankar Shastri.
Second respondent.
Admit post for final hearing. Call for the TCR. Yes, 49.
TCR already is there.
Already
49.
there. Admit
Girish
post
P.
for final
Baldar.
hearing. 49. No representation. List this matter in the month of November. 50.
My lord, appeal by the insurance company.
Hmm.
My lord, as per the FIR, my lord, Tata Nano is involved. Subsequently, Bolero vehicle.
What is the amount?
My lord, amount is, my lord, 12,95,471.
So you're questioning the involvement of the vehicle.
Yes. As per FIR, Tata Nano.
Hmm.
And as per charge sheet, Bolero goods vehicle.
So
And
it is
even a
submitted
driver
that
name is also there in the
The
FIR.
vehicle is implicated in this accident.
Also, driver also implicated.
They shall be stay on 50%. Say they are permitted to withdraw. Yes, 51. Notice to the respondent.
There is no DL, my lord. Charge sheet is filed under section 5 of motor vehicle.
Pay and recover. How much is the amount? Entire amount you have to pay. In these matters, if you want stay,
1,18,000.
the entire 100% amount shall be paid by the insurance company. And on such deposit, they shall be stay of all further proceedings. Yes, next 52.
52. Pawan Chandra Shetty.
Yes, no representation. List this matter in the month of November. Yes, 53.
53. Kailash Shankar.
Challenging liability, madam. Kindly issue notice to the respondents, madam.
Yes, notice. Yes, 54.
54. P. Suresh.
No representation. The list in the month of November. Yes.
55. KL Srinivas.
Same order.
Final hearing. 56.
I am for appellate.
Going to file wakalat for R1, R2.
Land counsel, Mr. D. Vijay Kumar submits that he has instructions to file wakalat. When are you going to file?
Week time. or
Yeah,
time.
seeks a week's time. List this matter after a week. Yes, next. Yes.
57. Harish Chennar. Harish.
No representation. List in the month of December. Yes, 58.
58.
I'm appearing for respondent.
Maheshwarappa.
My lord.
They're appearing for?
Respondent 5 National Insurance Company, my lordship.
Then there is one. Tata AAG General Insurance Company is also there. Who appears? Pradeep, you appear? Mr. B. Pradeep is there to take notice on behalf of respondent number 2 insurance company. Yes, list it. No representation on behalf of the appellant. Council shall serve the copy of the appeal memo on the council for the respondent insurance company. List it on 20th November. Is 59? Guru Prasad?
Please, my lord. My lords, I appear for the, I appear for the appellant, my lords. This is
Who
claimant's
appeared?
appeal, my lords. My lords,
United India
United
Insurance
Insur, it is served, my lords. No, no.
United India.
You appear.
It is.
Yes. AM Venkatesh.
No, the court will direct the council to take notice subject to the condition that whenever the matter lists, they will not ask for adjournment.
No, my lord. I will assist the court, my lord.
Mr. AM Venkatesh is directed to take notice on behalf of the respondent insurance company. Then council the appellant to serve the copy of the appeal memo on the council. List on 19th of November. Yes, 60.
60. Kailash Shankar.
You ready?
Please, sir.
Where is Mr. SV Hegde Mulkan?
He's in.
SV Hegde Mulkan.
Huh?
He's in court number 6.
What is the case?
I am challenging contributory negligence and also income of the deceased.
List it on 11th of November. No representation for the respondent. Is 61?
61. B.
Please, my
Pradeep.
lords, I appear for the respondent claimants.
Odd not.
Question is involved in this case, my lord. The income considered as per the chart, my lord, 15,500. The deceased was aged about 48 years, my lord. The future prospect considered 30% instead of 25%.
No.
And
What
interest
is the age?
48 years.
48 years is the age. Court has considered?
1/4 has deducted, my lord.
No, court had considered?
Same, 48.
No.
Future
48
prospects,
years, future prospects at
30%.
instead of 25%.
25%.
And then income,
Income, my lord, 15,500.
rightly considered?
Rightly considered.
Then what is the other ground?
Interest, my lord, 9% awarded instead of 6%.
So if the calculation is, what is the calculation?
Please.
So 15,500 plus 25% future prospects. It comes to 3875. It's coming to 19,375.
370.
How many are the dependents?
4 minutes.
1/4.
1/4 deducted.
Then it comes to 4843
Please.
minus 75. It's coming to 14 lakh
14,000.
3,125. Then 4 into 44.
Dismissal. Lordship.
1,76,000.
There 1,60,000 awarded, my lord.
The escalation has not been awarded.
In other
Not
things
3
you
years,
want,
2022.
wanted to be reduced, it will be increased in something else. 36,000, 10,000. No, yours is
Medical
no?
bills, my lord,
Yeah.
7,000.
Medical bills.
Medical bills are how much?
7,000.
7.
It's company appeal, my lord, 10,000 litigation.
No, that's what not given. General calculation, I immediately I wrote it.
Please.
14,53,125 plus 1,76,000.
My lords, it will come down to 22,66,875, my lords.
1 minute, 1 minute.
No, my lord.
16,65,125.
I think, my lordship, loss of dependency, my lordship.
My lord, loss of dependency, my lords, calculation, my lords, it
Loss
will
of
come down to
dependency,
22,66,875.
No, 15,500 is the income.
Please, plus
25%
25%.
future prospects would come to 3,875.
Please.
That is 19,375.
375.
In that 1/4 is deducted.
Minus
4,843.
843.
Comes to 14,000.
14,532.
532.
Into 12 into 13.
1 minute. 14,532 into 12.
Into 13.
Coming to 22 lakhs.
22,66,990.
992 plus 1,76,000 plus 36,000. It's
Plus
coming to
7,000.
24,78,000.
Plus 7,000 medical expenses.
992. Yes, 992 plus 7,000.
24,85, 992.
24,85.
992.
What was the amount granted?
25,54, 678.
25.
25,54, 6 to 8.
Please come.
Interest, my lord, 9% instead of 6%.
Agreed with the award passed in MBC number 1686 of 2022 dated 29 June 2024, whereby the court had granted the compensation of an amount of rupees 25 lakhs 54,628. Insurance company is before this court. Then counsel appearing for the insurance company submits that the court, when the age of the deceased is 48, court had granted 30%, is entitled for 25% future prospects. It is submitted that on account of interest, the court had granted 9%. It ought to have been at 6%. Then counsel appearing to the respondent claimants submits that the court, under the conventional heads, the amount that is awarded by the court is not reasonable, and it is submitted that on other counts, the court has granted a just and reasonable compensation. No interference is called for. Next, for having heard so and so, there is a material non-record. As rightly contended by the land counsel for the insurance company, when the age is 48, it ought to have been 25% future prospects, but the court has granted 30%. Hence, taking the income at 15,500, 25% future prospects would come to 3,875. Then the salary is 19,375. 1/4 has to be deducted towards the personal expenses. It comes to 4,843. Then the income, then his contribution to the family is 14,532 into 12 into what was the multiplier?
13.
13. The loss of dependency would come to 22,66,992. As there are 4 claimants, 4 into 44, 1,66,076,000 and 36,000 towards funeral expenses. It comes to 24 lakhs and 7,000 towards medical expenses. It would come to 24 lakh
85,992.
85,992. Accordingly, the appeal of the insurance and next after that, the interest, the claimant is entitled for 6%. Accordingly, the appeal of the insurance company is partly allowed by reducing the rate of interest from 9% to 6%, and also the compensation from 25,54,628 to 24,85,992. Yes, next.
Let's amount in deposit may be transferred to them.
Yes, amount in deposit shall be forthwith transferred.
62, Tejas N.
Appellant, my lord. Claimant appellant. Take time for seal is out of.
What is it?
Yes, requested me to take. Then today he is out of station.
No, what is the case?
Case of injury, my lord.
Yes, at request, list this matter on 26th of November. Next. Yes.
63,
Respondent.
Appear for appellant. Case of injury, enhancement, my lord.
Give it. Give the file.
The petitioner is the 24 years, my lord. Appellant is the 24 years, my lord. Chart is lower court is 12,000.
Which year is in? Which year is that?
2021. 2021.
21.
It should have been
15,000, my lord.
2021. Yes, 15,000. That is one aspect. Then that's the only thing.
Only things, my lord.
Please come to the table.
Table, my lord. Page number 18 in.
Page number 18.
Ink page number. Table. Illa.
I think there is no table.
Not table, my lord.
Where is in your synopsis? It must be there.
In synopsis, it is there.
Let's see the synopsis. So,
Towards
pain and suffering.
future,
How many are the injuries?
3 injury, my lord.
Fracture injuries. How many?
Fracture, my lord.
30,000 is another 10,000, my lord.
Under 20.
How can it be? 3 fracture injuries, is it not?
No, one fracture injury, my lord.
Then
One. Other one is tenderness. I'll leave to court, my lord.
15, my
So
lord.
we'll grant
Save measuring.
50,000.
Please, ma'am.
Then
15 days inpatient, my lord.
loss of income during laid-up period.
20,000 is awarded. 3 months may
He
be.
was in hospital.
15 days, my lord.
3 months may be granted.
3 months, my lord.
So 15,000 into 3.
45.
45,000.
45.
Then loss of
A minute.
No. How many days? He was in 15 days hospital.
15 days,
So
madam.
incidental expenses, how much is granted?
Only 10,000.
Not 10,000.
15,000.
25,000.
25,000.
25,000.
That is already on the higher side. We will not increase. 25,000. Then what is the disability according to the doctor?
33% whole body, my lord. 11%
What you are
is
taking?
1/3 is just and proper.
11% is considered, madam. 18 multiplier.
Multiple is just
15,000 into 12
into 18.
18
3
into
lakh
11 by 100.
3,56,400, my lord.
3 lakh?
56,400. Against 2,85,120 minus.
Cost of amenities, how much is granted?
20 is granted.
And the 10,000?
Please.
Legal expenses, 10,000. Medical?
Medical is not produced, any medical. Medical record is not produced.
He has not produced any.
Expenses.
No.
It's coming to 5,16,400 against 3,80,120. Please come. The claimant is before this court. Agreed with award passed in MVC number 152 of 2022, dated 30th March 2024, seeking enhancement of the compensation. The claim petition is filed seeking compensation for the injuries sustained by the claimant in the accident. The compensation of an amount of rupees 30 lakhs. The tribunal has granted the compensation as per the table given below. It's there in the synopsis, not there inside. The learned counsel for the appellant submits that the accident has taken place in the year 2021, and as per the chart, the court ought to have taken 15,000, but the court had taken 12,000 as the income. Further, it is submitted that under the head of pain and suffering and the loss of income during the laid up period, the amount that is awarded by the tribunal is not just and reasonable. Next para. Then counsel appearing for the insurance company submits that on all counts, the court has granted a just and reasonable compensation and there are no grounds to interfere. Next, having heard the so-and-so, the claimant had sustained one simple injury, one fracture injury and two simple injuries. Under the head of pain and suffering, this court is granting an amount of rupees 50,000. Then coming to the loss of income during the laid up period, this accident has happened in the year 2021, and considering the hospitalization of 15 days and the injuries, this court is granting for 3 months 45,000. Incidental expenses, court already granted 25,000, and this court is not interfering. Coming to the loss of future income, as there is no the material on record, as per the chart prepared by the as per the chart, it is 15,000 for the year 2021. Hence 15,000 into 12 into 18 into 11 by 100 is 3,56,400. Loss of amenities, this court is granting 30,000. In the light of the law laid down in Makel House, so and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 5,16,400. Accordingly, the appeal is partly allowed by enhancing the compensation from 3,80,120 to 5,16,400. Yes. Yes.
64, Pradeep B.
Yes, Pradeep.
Hearing for the plaintiffs. Yes, my lord, challenging the negligence as well as quantum of compensation, my lord. So far as negligence is concerned, my lord, the charge sheet is filed against the insurer of the motorcycle, my lord. There is an head-on collision, I pleaded that, my lordship. So far as future prospect has been considered, my lord, injury considered.
It's a case of death.
Case of injury, my lord. Zygomatic
Come to the
fracture.
table.
Please. Table.
Where is the table?
Please, my lord.
So, what are the injuries?
Para 28, my lord.
I'm looking at it.
Please. Fracture of zygomatic and orbital floor fracture, my lord. 2 fractures.
So, you would have got, if he is here, 60,000. Then, what is the disability?
43%.
To the limb.
No, my lord, he has assessed 43% permanent disability
The
The whole
MSCT
body.
consider one, please, not whole body, my lord.
limb.
Disability, MSCT coming to the conclusion, 1/3 of it, 14% has been considered,
It has been taken.
has been taken.
Ah.
The income, my lord, rightly consider 15,500.
Hmm.
As on the date of action, my lord, as per the chart, my lord, that same income has considered, internal page 20,
How many
15,500.
days he was in hospital?
8 days,
8 days.
8 days,
So even if you take it for 3 months, it was how much? 15,000.
15,500.
And then it would have been, on all the heads, it would be more.
Lordship, reconsider.
Huh?
Reconsider all the aids, my lordship.
Oh,
Modify the judgment, entire judgment.
no, it will be increased, no?
No, my lord, 6,56,000 loss of future earnings. That will reduce, my lord. 40% future
Then we will
prospects.
do that. Then we'll do that. 30,000. Medical and hospital expenses as it is. Loss of earning during the laid up period.
31,000 awarded.
15,500 into 3, how much?
46,500.
Okay, 46,500. Then he was there in hospital for 10 days.
8 days.
That will do. That will be sufficient. Then now future earning how?
Future earning, my lord, 15,500, 14%, 18 multiplier.
15,500. Disability is how much?
14%.
Yeah. Into 12 into
18, my lord.
into
18.
what is the disability?
14%.
14 by 100.
Please. Four lakh 68,720.
4,68,720.
Medical expenses, my lord, 2,16,000.
I am pain and agony 60,000.
60,000.
Plus 30,000 towards
Loss of amenities.
loss of amenities. 2,16,000
Medical expenses.
medical. 46,500. Yes, then 10,000 as it is. It's coming to 8,31,220. Yes?
Please, ma'am. Yes, ma'am. 8,31,000.
Please come. Agreed with award passed in embassy number 1352 of 2022, dated 8th December 2023. The insurance company is before this court questioning the quantum of compensation. Expert. The tribunal has granted the compensation as per the table given below at page number 28. Land counsel appearing for the insurance company submits that the tribunal has granted the compensation, excess compensation. It is submitted that there is a contributory negligence on the part of the claimant that has not been considered by the tribunal as it is a head-on collision. It is submitted that when the court, why this the future earnings have come to that?
14%.
No. Why the future earnings have come to 6,56,000?
15,500 added 40% future
It
prospects.
is submitted that when the disability is 14%, court had taken 40% future prospects. When the disability itself is 14%, question of considering the future prospects would not arise. It is submitted that the amount that is awarded at the head of loss of future earning is on the higher side. Though notice is served on the respondent, there is no representation. Next para. There is no representation on behalf of the respondent. Next, having heard the counsel for the petitioner, present material on record. The claimant had sustained 3 injuries.
Two fractures, ma'am.
2 fractures. Considering the same, this court is granting an amount of ₹60,000 at the head of pain and suffering. Coming to the medical expenses as submitted by, granted by the court, 2,16,000. Coming to the loss of earning during the later period, the accident had taken place in the year
22 million.
2022, and taking 15,500 for 3 months, it comes to 46,500. He was there in hospital for 10 days.
8 days.
8 days, and court had granted 10,000. There's nothing to interfere in this. Coming to the disability, court had taken 14%. Hence, under the head of loss of amenities, this court is granting 20,000. Coming to the loss of future earning, as rightly argued by the learned counsel, there cannot be any, there can't be future prospects for a disability of 14%. Hence, 15,500 into 12 into 18 into 14 by 100 is 4,68,720. 720. Altogether, the claimant is entitled for an amount of rupees 8,31,220. Then coming to the contributory negligence, the FIR is filed, the charge sheet is filed against the driver of the insured vehicle. There is no other independent evidence to show that there is contributory negligence. In these circumstances, this court is not inclined to go into that aspect, and the tribunal had rightly considered and held that the accident had taken place because of the rash and negligent driving of the driver of the offending vehicle. Hence, the appeal of the insurance company on that ground fails. Accordingly, the appeal is partly allowed and reducing the compensation from 9,63,000 to 8,31,220. The amount in deposit shall be forthwith transferred. If an amount any excess deposit, the insurance company is at liberty to withdraw. Yes, next.
6% interest.
And the rate of interest 6%. Reduced from it is already granted.
Granted 6% only.
Same, so the nothing to be, yes.
65. Ravishankar Shastri.
Appellant may not.
Yes.
Yagade Mulkan.
He is very much absent today, Mr. Mulkan.
Please.
Please smart no representation for the respondent listed on 11th November.
Please.
66.
66. Jay Kumar.
Also on the same day. 67, no representation on both the sides. 67, who appears?
My lord, here Ravishankar, my lord, first respondent kindly notice may be dispensed with, my lord.
Memo is filed in dispensation of notice to R1 dispensed with. No representation for the respondent insurance company. Counsel for the appellant is present, listed on 20th of November. Yes, 68.
As for the second respondent in this case, Your Lordship, this matter can be disposed of.
That's what, where is he?
It's only one, actually the tribunal has awarded excess compensation only for one TBF fracture. They have awarded 60,000, 1 lakh rupees towards pain and suffering, 68,000 rupees towards amenities.
Hmm.
And the
No
doctor
representation for the appellant. Counsel for the respondent is present. Lists this matter for dismissal on 12th of November. Yes, next 69.
69. B. Pradeep.
Maybe adjourn for other 3 weeks or 4 weeks. It's regarding the limitation, 6 months barred by limitation, claim petition has been presented. The same issue is pending before the apex court.
This is a matter in the month of December. Yes, call the password.
First door cases. List number 2, serial number 3. Shetty Vignesh.
Yes, let's read the judgment.
Please.
Before that, what is the judgment you relying on?
My lord, there are 2 judgments passed by this honorable court.
Let's see.
Yes. In fact, my lord, I produced my lord last week. So one judgment, my lord,
Kuttidin copy ಇದೆ either. Justice Suraj Govindraj and Justice Pandit judgment. My lord, in the WP number, my lord, 12038 of 2017.
Yes.
Passed by my lord Honorable Justice my lord Pandit. Kuttidin copy. I'll give you. My lord, I'll read my lord paragraph number 8, page number 5, in page number 5.
You're relying on Justice Pandit's judgment.
Please, my lord. In WP number, my lord, 12038. Very same, my lord, issue, my lord, where KPID, my lord, attach the things. This petitioner bank filed an application under section 14 of 2002 Act seeking assistance in taking possession of the secured asset. The second respondent deputy commissioner is obliged in considering the said application terms of section 14 of the Act. The attachment of the secured property under 2004 Act would have no priority over the claim of the petitioner. Section 26C of the 2002 Act makes it clear that notwithstanding anything contained in any other law for the time being in force, after the registration of a secured interest, the debts due to any secured creditor shall be paid in priority over all other debts. Admittedly, the secured asset were registered in the year of 2012 itself prior to on the attachment of secured property in 2004, i.e. on 23/6/2015. The apex court in the Punjab National Bank, while considering the priority of the bank claims of Surface Act, Customs Act, and is in circumstances of paragraph number 48 and 50, it is held as follows. In view of the above, we are of the firm opinion that the arrangements, my lord, I'll just keep paragraph number 48, 50, and my lord.
He considered that is a state act under central act.
My lord, subsequently, my lord, one more judgment passed by my lord Honorable Justice my lord Suraj Govindraj in the writ petition number 1880 of 2022. The order dated my lord 13 December 2024.
Keep all here. Yes. Which paragraph?
My lord, paragraph number 2. Page number 3. The petitioner is a bank who claims to be a secured creditor. In respect of respondent number 5, he had mortgaged the properties belongs to the respondent number 5 in favor of the petitioner bank as security for the loan advanced by the petitioner. The bank proceedings under Karnataka, the proceedings under Karnataka Protection of Interest and Depositors in Financial Establishment Act 2004,
He has
having been
relied on this order.
relied that order, and as well as my lord, the one judgment from
So
the
what
Honorable
is the
Supreme
other
Court.
discussion? Let's look at any discussion is there in any other judgment.
I'll just point out, my lord, in the Honorable Supreme Court passed in recent order, which my friend is relied.
Huh.
Lord, that case is completely, my lord, different from my case. My lord, kindly come to my lord, in page number 6.
No, whether the Honorable Apex Court has decided the Securitization Acts, these are this?
Please.
That's the issue.
That's all.
So
The
that
Honorable
we will, that's why what we do is we'll read it from the beginning.
Please, my lord. Please, my lord. Entire judgment. Facts in the show, my lord. Brief facts.
Would my lord permit me to take the relevant paragraphs, my lord?
Yes.
In month of December.
At page number 7, my lords. Before that, my lords, would my lords permit me to just narrate, my lords, the facts which fell for consideration before the Honorable Supreme Court. The NSEL, my lords, the National Spot Exchange Limited, was one financial establishment under the provisions of the MPID Act, my lords. There, my lords, certain questions came to be raised. One such question was whether, my lords, the provisions of surface will prevail over the provisions of MPID. But the Honorable Supreme Court, in exercise of its powers under 142, my lords, constituted a committee and, my lords, empowered the committee to go into certain questions, my lord. And all the stakeholders were, my lords, directed to assist, my lords, the said committee. The committee, my lords, on holding the proceedings was returned finding on two issues. One, my lords, was it categorically held that because the money is a tainted money that belonged to the depositors, the provisions of MPID will prevail over the provisions of surfacing.
That finding will go.
Please, Lord. And the second issue also.
That's one.
Please, Lord.
If that is the case, if such a straight finding is given by the court, whatever are the facts and circumstances on a legal issue, it would be correct.
Indeed,
So
Lord.
where is that? Where
Please,
is that we will go?
I'll only take para 44 by lots is comprehensive.
42 is relevant.
I'll read para 42 and then go backwards.
Before that, my lord, kindly come to my lord, page number 6. The facts is totally different in that case.
No, it's we are on a legal position.
That's what, my lord. There, my lord, attachment in there of 2013. There are 13,000
attachment under the
KPID Act or, my lord,
that
MPA,
act
sorry,
is much prior to the securitization.
Where, my lord, in the paragraph number 42, the Honorable Apex gets swelled.
Where are the facts that we
Page number 42. So paragraph number 42. It said
paragraph
42. My lord, in page number 69. 69 of the judgment, my lord.
Let's see.
It was next sought to be submitted by learned counsel for appearing for the secured creditor that view of the section 26 of Surface Act, the debts due to the secured creditor have to be paid priority over all other debts and all revenues, taxes, cesses, and other rates payable to the central government or state government or local authority, and therefore the security interest of the secured creditors in respect of the properties attached under MPID Act should be given priority. We do not find any merit in that submission apart from the fact that section 26E has come into force from 1st September 2016. It gives right to the secured creditor after registration of the security. In my case, my lord, my mortgage in there of 2020.
Here in this case, it is
2013. Please, my lord, come to paragraph number 6 of the, my lord, page number 6.
No, we'll continue reading this.
Please.
We'll continue reading.
Page number 40, my lord, subsequent to the, gives right to the secured creditor after the registration of security interest to be paid in priority over all other debts and revenues, taxes, etc., payable to the central government or state government, local authority. 43. In an instant case, the attachment of the properties of the secured creditor is said to have security interest have been attached under section 4 of the MPID Act. Such properties are believed to have been acquired by the financial establishment, that is NSEL, either in its own name or in the name of other person from the deposits collected by the financial establishment. All such properties and assets of the financial establishment and the persons mentioned in the said provisions vest in the competent authority appointed by the government pending further order from the designated court. Such monies or deposit or depositors investors who have been allegedly defrauded by the financial establishment and the recovery of which the MPAD has been enacted could not be said to be a debt complaint contemplated in section 26E of the SARFAESI Act, and hence also provisions of this section 26 could not be said to have been attracted to the facts of the
No,
case.
under the MPID Act, when the proceedings are initiated in this case?
In this case, 2013. That's what, my lord, I'm pointing out. My
And
lord,
the SARFAESI Act? No. Under the MPID Act,
please, my lord.
the properties were attached when?
My lord, in this, my lord, that's
This case, in the
judgment passed by the Honorable Supreme Court.
2013, my lord.
2013. My lord,
And securitization proceedings were
subsequent to that,
initiated
not
probably after 2016.
2016. Therefore, the Honorable Apex Court said that that 26E came
not come into play.
Hey, that is the reason this case is, my lord, not in my case, my lord, it is not.
So what it said is such monies of deposit or who have been allegedly defrauded by the financial establishment and for the recovery of which the MPID Act has been enacted could not be said to be a debt contemplated in section 26E of the SARFAESI Act. Hence, all the provisions of section 26C could not be said to have been attracted to the facts of the case.
Please.
May I make a submission? But because the fact, we do not have a competing interest. This is not one of those adversarial form of litigation we're assisting the court. But the question now is whether the provisions of SARFAESI prevail over, and there's a reason, my lord. My lords will kindly appreciate. I will take my lords right from paragraph number 4 and the finding of the committee and then how it came before the Honorable Supreme Court. The dates fail into insignificance. My lords may kindly.
Yes, that to show. That's
please,
what I wanted.
Please, my lord. My lords may kindly take to paragraph 4 at page number 19, my lord.
Yes.
And for the purposes of when was the MPID Act invoked, my lords will kindly take page number 7, was Roman small 9, my lords. Page number 7, Roman 9, my lord.
No, you said paragraph number 4.
I'll just point out the date, my lord, or the year in which, my lords, MPID Act was invoked.
Page number 9.
Page number 7, my lords.
Yes.
My lord, Roman 9, from the foot of the page, line number 9, my lords. The provisions of so and so. I'm able to point out, my lords. The provisions of the Maharashtra Protection of Interest of Depositors Act 1999 were also added to the said FIR in October 2013. So the date on which the MPID Act was invoked was sometime in October 2013. But the date on which SARFAESI proceedings were initiated, my lords, do not find a bearing. I say so for this reason, that their lordships, my lord, have not gone on the dates, but on the purpose of the Act. And I'll point out, para 42, my lords will again read it, my lords.
In this case,
please,
the proceedings under this MPID Act were
please,
initiated in the year 2013.
13,
so, coming to the facts,
please.
Where do we get it?
SARFAESI, the date of SARFAESI, my lords.
SARFAESI, anyhow, it would be after 2016. The Act itself has come in 2016. Please. So now we'll go back to the facts where they say the proceedings under the MPID Act.
Please, Lord. Page number 19, page number 19, paragraph 4, my lords, may kindly see, my lord. This is what the Supreme Court committee held, and then, my lord, that is, my lord, the basis. Para 14, para 4.
My lord is asking, my lord,
I'm asking about the
paragraph number 6, page number 6, my lord, page number 6. My lord, paragraph number 6.
My lord, instead of reading it in bits and pieces, only.
No, this is relevant because ultimately, whatever both of you argue, it is for my understanding.
Please.
So, first of all, I have to understand.
Please, Lord.
So, I want to know in these proceedings, in this case, MPID proceedings were initiated when?
2013, my lords. In the case before the Honorable Supreme Court. Please, no dispute on that.
No. So, when the SARFAESI proceedings are initiated, that is nowhere relevant because it is definitely subsequent to this MPID proceedings.
Please.
That's what the court recorded. In those circumstances, this 26E, which has come into force in the after 2016, in the year 2016, you cannot say in the light of it, an act which has come before in the year 2013 and the proceedings initiated, or will it have a bearing on 2016? So now whatever that is read in bits and pieces,
my lords,
makes it clear that the Honorable Apex Court has not laid down such a ratio that whenever the proceedings under the MPAD and the SARFAESI are initiated, the MPAD proceedings will have a overriding effect on this.
Please, must permit me to submit this.
In the present case, 26E will apply for the petition.
The entire case was.
Now, because the court is with you, the submissions he will only make.
My lords, but even as my lord, but if at all the Honorable Supreme Court were to have held that in terms of, my lords, the point of first cause of action, in terms of 26E or in terms, my lords, of which cause of action is accrued.
Before you proceed, one more thing.
My lord,
Now, the Surface Act is a central enactment.
please, my lord,
This is a state act.
please, my lord,
Generally, without going into any of the facts,
Please.
when there is a conflict, the
Please.
central enactment will prevail.
with one rider, my lord. My lord, the state enactment having been reserved for the assent of His Excellency the President, the state enactment has indeed received the assent of the President of India. That one,
The difficulty is notwithstanding
please, my lord,
any other,
the Supreme Court considers that. In this case, my lord,
any other proceedings,
Please,
every
my lord.
act will say
Please,
with a
my lord.
non-obstacle clause. So ultimately, what is withstanding is the issue.
please, my lord, when two enactments, my lord, have a non-obstante clause, but the special act and the general act shall have to be gone into. So the Supreme Court will have, my lord, has appreciated in these facts and circumstances which act can be held to be a special act and which is the act that can be held to be a general act. It is in this context that in para 42 their lordship say
So let's
that
see.
it cannot be held to be a debt.
Let's see.
Please, my lord. My lords would permit me to refer to para 4, my lords. That is, my lords, the
Yes.
beginning of the litigation on this point, if I can say so.
Yes.
Plus, the Supreme Court appointed committee held so in para 4, my lord. In view of the aforesaid stated factual matrix, the Supreme Court committee raised an issue as to whether the secured creditors would have priority of interest over assets attached unto the provisions of
The
PF.
reading paragraph number?
That's para 4, my lords. Para 4 at page number 19, my lord. Page number 19, my lords. Para 4, my lord.
Yes.
In view, am I able to point out, my lord? In view of the aforesaid factual matrix, the Supreme Court committee raised an issue as to whether the secured creditors would have priority of interest over assets attached under PMLA and MPID by virtue of the provisions of the Securitization and Reconstruction of the Financial Assets and Enforcement of Security Interest Act 2002 and the Recovery of Debts and Bankruptcy Act 1993. Para 5. The Supreme Court committee addressing the said issue concluded the order dated 10/8/2023 that given the overriding effect, the secured property being in the nature of proceeds of crime as held by the attachment orders, no priority of interest can be claimed by the secured creditors against such attached property. I stop here for a while with my lord's kind permission. Kindly see, my lord, the reasoning on which, my lord, the MPID Act was held to have priority over the provisions of Surface. It was not in terms of 26E. It was not in terms of, my lord, any other provision of law. It was not the interpretative exercise of Article 254 vis-a-vis the Union List 1, List 2, List 3. It was on the ground, my lords. And again, my lords will permit me to read this. The secured property being in the nature of proceeds of crime as held by the attachment orders, no priority of interest can be claimed by the secured creditors against such attached property. As regards the properties attached under the MPID Act on which the secured creditors laid their claims, the Supreme Court committee further concluded.
Actual matrix do bear, there is a relevancy. If you see,
My lord.
as regards the properties attached under the MPID Act, on which the secured creditors laid their claim, the Supreme Court committee further concluded the provisions of the MPID Act would override any claim for priority of interest by the secured creditors in respect of the property. So, in this case also, the secured creditors' interest is first. In your case,
My lords.
present facts also,
Please, no.
their interest is created first.
But
You
I'll point out to the chronology of order of events.
Hmm.
Plus, the sale certificate has been issued much after the invoking of.
No, the surface proceedings will not, that's not the starting date of issuing the sale certificate. The day the NPA is, once it is
2021.
declared as NPA, 13(2) notice is issued, the proceedings are initiated.
I'll come to that, my lords.
Hmm.
My lords, I'll come to that, my lords. Ultimately, my lords, my lords are laying down the law. I'll assist the court, my lords.
Yes.
Para 7, my lords, may kindly
Yes,
take.
yes.
At this point of time, my submission would be, my lord, the dates may not have a bearing on, my lords, the judgment is my humble submission.
Yes.
Para 7, the Supreme Court, my lords, it may not be relevant as far as the IBC is concerned. Lords, now my lords may permit me to take my lords to para 20 at page number 39, my lords. The scope of 142 and other things have been discussed. I'll not trouble your lordships with that.
Yes,
Page number 39, my lords. Question number 1, para 20. So far as the question as to whether the secured creditors would have priority of interest over the assets attached under the provisions of PMLA and MPID by virtue of so is concerned, it would be beneficial to first refer to the objects and reasons and the relevant portions of the said statutes, as also the Constitution of India. Now, I'll take my lords to para 22, my lords. As the long title of SURFACE Act suggests, it was enacted to regulate the securitization and reconstruction of financial assets and enforcement of security interest, and to provide for a central database of security interests created on property rights and for matters connected therewith or incidental thereto. SURFACE Act came into force with effect from 21/6/2002. Section 26E having been relied upon by the learned counsels for the secured creditors, the same is reproduced as under 26E, my lords. Section 35, which I'll skip that, my lords. Para 24, my lords, may kindly take. The MPID Act, I'm able to point out, my lords, please, my lord. The MPID Act was enacted by the state of Maharashtra to protect the interest of depositors of the financial establishments and matters relating thereto. Some of the provisions of the said Act being germane for deciding the issues involved in the present proceedings. The same are reproduced herewith. But I'll skip all those sections, my lord. My lords, may kindly take 51, my lords. Para 26, my lord, analysis, my lord. It is right that the court, while interpreting the statutes, which is arguably the conflicting provisions, has to keep in mind the federal structure embedded in our constitution as a basic structure. As per Article 246, Clause 1 of the Constitution, notwithstanding anything contained in Clauses 2 and 3, the Parliament has exclusive power to make laws with respect to any of the matters enumerated in the List 1 of the 7th Schedule referred to as the Union List. As per Article 256, Clause 2, notwithstanding anything in Clause 3, the Parliament and subject to Clause 1, the state legislature has power to make laws on any of the matters enumerated in List 3 in the 7th Schedule referred to as the concurrent list. As per Article 256, Clause 3, subject to Clause 1 and 2 of Article, the legislature of any state has exclusive powers to make laws for such state or any part thereof with respect to any of the matters enumerated in List 2 in the 7th Schedule referred to as the state list. Thus, a threefold distribution of legislative power between the union and the states made in 3 lists in the 7th Schedule of the Constitution, read with 246, exhibits the principle of federal supremacy, that in case of inevitable conflict between the union and state powers, the union power as enumerated in List 1 shall prevail over the state power as enumerated in List 2 and 3, and in case of overlapping between List 2 and 3, the latter shall prevail. In view of such distribution of legislative powers, situations have arisen where 2 legislative fields have apparently overlapped. In such situations, this court has held that it was the duty of the courts to ascertain as to what degree and to what extent the authority to deal with the matters falling within these clauses of subjects exist in each of such legislatures and to define the limits of their respective powers. The discussion, my lords, the various judgments of the Honorable Supreme Court and other courts have been, my lords, referred to. My lords, in view of that, my lords may permit me to take 42, my lords.
42.
Para 42 at page number 68, my lord. It was next sought to be. But I'll sorry, my lord. My lord may permit me to take 41, my lords, because some discussion. I'm sorry, my lords. It is true that sometimes the overlapping of legislations enacted with regard to the matters relatable to different entries in List 1 and List 2 in 7th Schedule may occur. However, in that case also, as was held by Constitution Bench in so and so, though the List 1 has priority over List 3 and List 2, and List 3 has priority List 1, the predominance of Union List would not prevent the state legislature from dealing with any matter within List 2, even if it may incidentally affect any item in List 1. In the case at hand, the SURFACE Act and the RDB having been enacted by the Parliament for the subject matter falling in List 1, and the MPID Act having been enacted by the state legislature for the subject matter falling in List 2 in the 7th Schedule, the latter would prevail in the state of Maharashtra in respect of the specific subject matter for which the said act was enacted in view of Clause 3 of Article 246. My lords, may kindly permit me to stop here for a while, my lords. But if at all both the acts, my lord, have, my lords, non-obstante clause, the Honorable Supreme Court in para 43, my lord, would not have employed that phrase or the sentence that I'll read to your lordships, my lord. Now, in plain terms of the availability of power in the federal structure and the interpretative exercise of the federalism, the Honorable Supreme Court, my lord, analyzing 256 in view of 1, 2, and 3, in terms of 256 clause 3 has categorically held that the provisions of MPID shall prevail over the provisions of SURFACE Act. Dehosts the fact that the proceedings having been initiated earlier or otherwise has not at all been a subject matter of, my lords, the consideration. In fact, my lords, in the first session, my learned senior friend was referring to obiter dicta and ratio. But I ask myself, in terms of Article 141, would it be, my lords, available for me to argue that obiter dictum is not a law laid down by the Honorable Supreme Court?
No, when the Supreme Court says, like, or any court for that matter, in the fact and circumstances,
Please, my lord.
this is the stand.
Please, my lord.
Laying down a ratio is a different aspect. That in the facts and circumstances, we take a view.
Please, my lord.
Then that will not apply generally.
Please, my lord. My lord, kindly permit me to assist the court with this, my lord. If the Honorable Supreme Court were to have held that the proceedings under the MPID Act have been initiated on so and so, the proceedings under the SURFACE have been initiated by the Secretary on so and so, having considered the fact that there is a difference in terms of priority or in terms of time, if the Honorable Supreme Court were to have held so, my lords, I would have bowed down. But here, my lords, in all humility, the Supreme Court has not gone on the question, my lords, of the point of time. It has gone on the question of the legislative power available to the state and the federal, my lords.
Well, still this finding, not able to understand.
My lords, I will, my lords. I will, my lords.
No,
Because I have,
no, you please read this 246(3).
my lord,
Constitution
please, I will,
246.
my lords. Before, my lords, I read 246 clause 3 because there are two.
That's what I'm saying, 246(3), you please read.
Please, my lord. My submission is before I take, my lords, to the constitutional text, my lord, because there's one line, my lords, one line which makes a difference. If I'm not able to.
No, the state list 1, the center is empowered, list 2, and the third list. Then the finding that in the case at hand, the SURFACE Act and RDBA Act having been enacted with the Parliament for the subject matter falling in list 1, and the MPID Act having been enacted by the state legislature for the subject matter falling in list 2. In the 7th schedule, the later would prevail in the state of Maharashtra. Here we are dealing with the conflict of two acts.
In fact, para 40, my lords, would answer this question, my lords. Para
I'm
40.
looking at 41, I think it is.
If you could start from 40, in fact, 40, my lords, considers
let's
the
see,
pith and
let's see.
substance. Para 40 considers the question of pith and substance, my lord. Para 40, in view of the above position, my lords.
Yes. Yes, please read.
Please, my lord. In view of the above position of law settled by the Constitution bench, it is held that considering the pith and substance of the state and the central legislations in question, the central legislations, that is SURFACE or RDB, cannot be permitted to prevail over the state legislation MPID Act merely because the state legislations are enacted by the Parliament. Since all these acts have separate field of operation, provisions of SURFACE Act or RDB cannot be permitted to override the provisions of MPID Act, which is a validly enacted state legislation. Otherwise, it would tantamount to violation of federal structure doctrine envisaged in the Constitution. The respective legislative powers of the Union and the states are traceable to Article 245 to 54 of the Constitution. The state where the Constitution is federal in structure and independent in its exercise of legislative and executive power. Therefore, if provisions of SURFACE Act or RDB Act are permitted to override the provisions of MPID Act, then the legislative powers of the state legislature would be denuded, which would tantamount to subverting the law enacted by the state legislature. So at this point of time, neither my learned brother nor me, we can, my lords, comment on the correctness or otherwise of their lordship judgment. In terms of Article 41, my lords, it is the gospel truth. It is the grand norm. Unless my learned brother were to say that there is, my lords, a review petition filed and allowed, and this order recalled, but we may not be able, my lords.
No, it is a categorical finding saying that.
That's not all. But that's not all.
Only MPID Act would prevail over the SURFACE Act.
Matter of fact, this is a, my lord, judgment passed by the Honorable Supreme Court, wherein, my lord, the set of facts are different. There are 13,000 depositors in the year of 2013, my lord, and that is the reason I would like to point out, my lord, paragraph from page number 6. The facts totally different than my case.
Understand? No. If we read the other paragraph which he has read in
42, 43, 41,
facts and circumstances, they said so. But before saying that facts and circumstances, they have dwell upon the legal position also. And now they've given a finding that when there is a state act and central act, the state act will prevail.
Merely
My lord,
because
one
the
minute,
word.
brother, 1 minute. My lords would kindly see the reason, my lords. One more important reason. Whether, my lords, the Honorable Supreme Court, though not in too many words, because I've had the benefit of assisting the Honorable Supreme Court in this matter, though not directly. The question that fell was consideration was whether both the acts are covering the concept of debt. If not, then, my lords, there is no clash or there is no, my lords, overlapping is what the Supreme Court has held. That's the reason.
So in any other case also, so what we have to understand from this judgment is when there is a central enactment and state, only state enactment will prevail.
I'm sorry, my lords, I'm not able.
We are not saying anything. We are understanding from the judgment, from this particular observation now, that law or that whatever that is ruling saying that what we learnt earlier is that the central enactment will prevail. Now we have to say that it's the
State
only
enactment.
state enactment that would prevail on under the, they have not said anything in specific to this MPID. This, they didn't even say, it has been like very long and
Very true.
Please. In
interpretation.
fact, one difference, maybe one observation of the Honorable Supreme Court, my lords, may put all the things at rest. I would make I persuade your lordships, my lord, to read the last 4 underlined lines of para 43, my lord. Such, the reason, my lords, the reason why the Supreme Court says so, though not in too many words, this may be the one which makes the difference, is my humble submission. Such monies are deposits of depositors, investors who have been allegedly defrauded with the
Again, you are coming here if this para is completely specific to the facts of the
case.
So that we will not. No, the
Para 44, my lord.
which are going against him is all these 40, 41 and
42.
And ultimately para 44, my lords. Para 44, my lords, in that view of the matter, it is held that no priority of interest can be claimed by the secured creditors against the properties attached under the MPID Act. I stop here for a while. If, my lords, there is no next sentence, because if at all the Honorable Supreme Court had left it at that, saying that we cannot say that there is a priority interstate between the acts, then the question as to under which action has been initiated first, my lords, would come into operation. Their lordships did not stop at that, my lord. My lords will kindly now permit me to read the next sentence, and my lord will kindly take the trouble of reading this paragraph with this line and without this line. My lord will now permit me to read, my lord. Against the properties attached under the MPID Act, and the provisions of MPID Act would override any claim for priority of interest. So this sentence, my lord, if the lordships have stopped at that point where they said that there is no priority interest, say, because it was open for discussion. It was open for us to say, my lord, the facts are different. So this, my humble submission. And the last thing, the 2 judgments that my learned brother has referred to, I would in all humility submit that they are more academic.
In the light of this, we cannot
Please,
consider it.
because this court did not have the benefit of this order. Please,
Having this order.
please.
If I have to assist also in considering all the arguments that is advanced. For a judgment to cover an issue, primarily the facts have to be, a lot will be laid down, also facts have to be similar.
No. I am also on that
I
point
understand.
initially.
The background in which the judgment has been considered here is in the absence of section 26E. Now there are 2 non-obstant clauses. No, there are 2 non-obstant as per the submission.
That's a whole difficulty.
No, I get that.
But now there is the Supreme Court has categorically considered Article 246(3) and says that in the light of 246(3), the state, it prevails. They've given that is the ratio laid down.
Even I had the opportunity to read the judgment 3-4 times just to understand the intent of the judgment. Now, the background in which the judgment is passed in the absence of section 26C. It was considered in the light of 2 non-obstant clauses coming in the way of each other, which is in operation in the same field. If that is so, then they said that they interpreted Article 246.
When they say, no, please understand. When the Honorable Apex Court says that it is the MPID Act alone prevails, question of 26C also will not come.
MPID Act would prevail in case there is a conflict between the acts. There was 2 non-obstant clauses, that is section 31 and certain section of MPID Act, which said that notwithstanding the application of any other laws timely in the court, these acts would prevail. In this background, the Honorable Supreme Court considered the matter and laid down the law. Section 26C, which clearly says that debts owed to the central government would not be considered because Surface Act will take priority over those debts.
That aspect was not at all considered because that came in 2016. So the background on which the Supreme Court considered the case is completely different. It was only on two non-obstant clause being in operation.
That's the whole problem. If that's what, initially that's what I thought. 26E, it came into existence in 2016. This is 2013. So that's what is the interpretation given. Now, if you further look into it, a clear finding saying that MPID Act will prevail over the Surface Act. Notwithstand, then when Act itself is prevailed, why do you look at one particular provision?
The Act, because the,
No, it's a generalized, it's a ratio.
The generalized, the entire background is that there were two non-obstant clauses. The Supreme Court considered non-obstant clause in this Act. Supreme Court considered non-obstant clause in that Act. But the provision which clearly has an overriding effect over the other Act was not considered. 26C is the key provision which has clearly an overriding effect over the
I think
other
that is then we'll be debating on the judgment because it is very clear. But
Well, that's not what I meant, Lord, that when neither my learned brother nor me, Lord, we have to accept the law as it is. We cannot either add words or sentences or take out any words or sentences.
Single coordinate benches.
no, what we do is, that single, because they didn't have the benefit of it.
Judgments, 26C is considered. It is not 31 that is considered. In the two judgments that this Honorable Court has rendered, clearly only 26E has been considered in the judgment.
The Supreme Court has gone little forward now, little further. So what I do is, like some other day in the coming week, I'll keep it. That day, if you come up with something else, we'll consider.
Certainly, my lord.
Or else, then we have to, following this judgment, we have to pass order.
Lords, for the ready reference of my lords, whatever sections the Honorable Supreme Court has referred under the MPID Act, I have made a table, my lords, with just the change of the sections. It is identical, my lord.
No, there is no dispute on that. It is parametry with what this KPID is.
There are few sections where they have, I think MPID there are 12 or 13 sections. We have around 26 sections.
It's all states have a kind of legislation. So that's not the issue. No, it is the state and central. That's the issue. And the law laid down is now.
In fact, I have one submission. I would depart. I mean, so far I was with the petitioner in the other case. Now, if it is so that the judgment laid by the Honorable Supreme Court is to prevail, I have to depart from here and then I have to make a submission that I am a purchaser who has paid 7 crores consideration for procuring this property. I participated in the auction which was published and then I purchased the property. Sales certificate.
You want refund of the money?
I want refund of the money along with some interest.
In fact, my lord, in fact, the coordinate bench of my lords has always given him a liberty to approach the bank and take the money.
No, it's not so. It's not so. My lord may decide.
That's what. And instead of keeping it in between, next week, we'll have it on 29th.
25th, my lord, if not too many matters are listed, subject to my lord's kind convenience, my lord.
We'll have it because all the matters I'm saying 25th because no matters. We'll see that day if it can't happen. Then next day next week.
To prepare, 2 days would be a little short.
It is their application. It is their application for early hearing. I have no difficulty.
No. With all this background, they require some time. So we'll have it. We'll have it on 30th. It's like we'll get some considerable time. 30th.
Please, ma'am.
List number 4, serial number 5. Raghuvar.
Where is Geeta?
Geeta?
Yes.
My lord, they want time next week. Any next week? Any date, madam?
This matter, at the request of the request of the insurance company on 25th is fine.
Yes, madam.
25th month? No.
Next week.
Next week.
Nobody wants date on 25th, but the court works on that day.
Yes, madam.
4th November.
Yes, madam.
Same stage. Same stage.
Same stage.
My lordship, kind permission, madam.
Serial number 57 in the fourth list, madam. I'm sorry, my lord, I could not appear.
What happened?
My lord, it's dismissal post. It is posted for dismissal, my lord. Kindly, I will argue the matter.
Same day without dismissal. What is that number?
Serial number 57, the fourth list.
Then council response submits the interim order has not been complied with. If the interim order, but you have shown me something else. That's what I remember. That's why I said, as it is a current district and transfer catering, the respondent is always at liberty to execute the order. Interim order earlier granted. Whatever it is, delete from the caption dismissal. Earlier granted is extended. Yes.
My lordship. Pardon me, my lordship. My lordship, you moved the memo in the morning, my lordship. But 18th also moved date and given on 3rd, my lordship. But action will going on Friday, my lordship. Bank, kindly have it and tomorrow, my lordship. In repetition number 314401.
I've seen all the memos, wherever the urgency is mentioned, I've given the
I
dates.
mentioned, my lordship.
If it
But
is
not yet
mentioned-
come, my lordship. 18th already moved, my lordship, my colleague. But date is given on 3rd.
Yet, if you look at that, you will find when is it? When is the date given? What it indicates now as per the status?
What is the date given earlier?
3rd, my lordship, coming next month, my lordship.
Hmm.
But we moved it today also, my colleague has moved my lordship, but
But when in the memo, when you are not mentioning the urgency, what the court can do?
my colleague has moved in the morning, my lordship. He's told the urgency is there.
Then
But
I
lordship,
must have, I have already given the dates again. Like, what is the number? You have the memo, tell her what it is. Yes.
for oblige, my lordship.
Urgency mention
ಡಿಸ್ಮಿಸಲ್ ಪೋಸ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು ಮೇಡಮ್ ನನ್ನ ಪೇರ್ ನನ್ನ ಪೇರ್ ಅವರು ಅದಕ್ಕೆ ಡಿಸ್ಮಿಸಲ್ ಪೋಸ್ಟ್
ಕಳಿಸಿಲ್ವಾ? ಕಳಿಸಿಲ್ವಾ?
57 ಸರ್ ಫೋರ್ತ್ ಲಿಸ್ಟ್
ಕಂಡೀಷನ್ ಆಗಿಲ್ಲ 57 ಮಂತ್ ಆಫ್ ಡಿಸೆಂಬರ್ ಅಷ್ಟೇ ಆಗಿದೆ. ಕಂಡೀಷನ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಆಗಿಲ್ಲ.
ಡಿಸ್ಮಿಸಲ್ ಅಂದ್ರೆ ಅಪೋಸಿಟ್
ಇಲ್ಲ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಬಂದ್ರು ಅವತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಷ್ಟೇ, ಅವ್ರು ಡಿಸ್ಮಿಸ್ ಮಾಡಲ್ಲ. ಸ್ಟೇಜ್ ಡಿಸ್ಕಷನ್ ಅಷ್ಟೇ, ಕ್ಯಾಪ್ಷನ್
ನನ್ನ ಪೇಸ್ ಆಗಿದೆ ಸರ್, ನನ್ನ ಪೇಸ್
ಅಂದ್ರೆ ಅವತ್ತು ಬೇಗ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಕೇಸ್ ಮುಗಿದೋಗ್ಬಿಡುತ್ತೆ ಅಂತ. ಅದ್ಯಾವುದೋ ನಂಬರ್ ತಗೊಳ್ಳಿ, ಅದನ್ನ ಮೆಮೊ ತಂದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವತ್ತು ಮೆಮೊ ಮಾಡಿದ್ದಾರೆ.
ನಾವು ರೆಡಿ ಇದೀವಿ, ಬರೀ 70 lakhs ಗಳು. ಅದಕ್ಕೆ 2 weeks projects ಕೊಟ್ಟರೆ we are
ready to pay the
remaining
amount which is whatever is
ನನ್ನ ಪೇಸ್ ಅಂತ ಆಗಿದೆ.
any number.
ಅದಕ್ಕೆ ಮೆಮೊ
ಅದೇನು ಮಾಡ್ಬೇಡಿ, ಡೇಟ್ ಕೊಟ್ಟು
ಕುಮಾರನೇ ಬೇಡ.
ಹೌದಾ? ರಿಕಾಲ್ ಮಾಡ್ಬೋದು, ಜಸ್ಟ್ ಡೇಟ್ ಹೇಳಿದ್ರೆ ಅಷ್ಟೇ. ಅವಾಗ ಬೆಳಿಗ್ಗೆ ಅವಾಗ ಮಧ್ಯಾಹ್ನ ಬಿಎನ್ ಅದು ಯಾರು ಸೀರಿಯಲ್
ಹೌದಾ? ಓ ಟ್ಯೂಸ್ಡೇದು ಅದಕ್ಕೆ ಸರ್ ಒಂದು ಹೇಳ್ಬಿಟ್ಟು
Sir. No representative, no representation ಅಲ್ವಾ ಅದನ್ನು?
65 ಬಂದಿರೋದು
ಇಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್
ಸರ್ ಸರ್ ಮಾತಾಡಿದ್ರೆ ಇನ್ 20 minutes ಅಂದ್ರು ಸರ್.
2011 ಅಲ್ವಾ?
ಇಲ್ಲ ಕೋರ್ಟ್ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದ್ದೀವಿ.
68/12/11, 69 December 25.
ಇದು ಫಸ್ಟ್ ನಾವು ಆಲ್ರೆಡಿ 18th ಮೂವ್ ಮಾಡಿದ್ವಿ, ಅದು 3rd ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವತ್ತು ಮೂವ್ ಮಾಡಿದೀವಿ, ಕೊಲಿಗ್ ಮೂವ್ ಮಾಡಿದೀವಿ,
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ,
ಏನು ಹೇಳಿಲ್ಲ. ಅದಕ್ಕೆ ಸಬ್ಮಿಷನ್ ಯಾಕಂದ್ರೆ ವಿ ರೆಡಿ ಟು ಪೇ ಎಸ್ಕ್ರೋ ಪ್ರಾಪರ್ಟಿ
ಹೇಗೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಗೊತ್ತಾ ನಿಮಗೆ? ಅದು
ಅಡ್ವರ್ಟೈಸ್ ನಮ್ದು ಇದೆ ವೇಸ್ಟ್ ಮ್ಯಾಟರ್ ಮುಂದೆ.
ಈ ತರ ಏನೋ ಒಂದು ಆಡು ಶೀಟ್ ಕೊಡಪ್ಪ. ಇದು ಇದಿಲ್ಲ ಇಲ್ಲ
ಇದೆ ಫಸ್ಟ್ ಟೈಮ್.
ಇವ್ರ ಮುಂದೆ ಹೆಂಗೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಟಿ ಆರ್
NP ಇದ್ರೆ ಚೆನ್ನಾಗಿ ಹೋಗ್ಬಿಡುತ್ತೆ. ಅಟ್ಲೀಸ್ಟ್ ಒಂದು 2 weeks 1 week ಆದ್ರೂ ಟೈಮ್
ಕೊಡ್ತಾ ಇದ್ರು. ಹೌದು,
ಇವ್ರೇನ್ ಲಿಬರ್ಟಿ ಇದಾರೋ ಇಲ್ವೋ
ಅದೇ ಗೊತ್ತಿಲ್ಲ.
ನೀವು DRT ಬಂದಿದ್ಯಾ ಸರ್ ಮೇಡಮ್? DRT ಸರ್ ಸರ್
ಸ್ವಲ್ಪ ಕನ್ಫ್ಯೂಷನ್
ಅಲ್ಲಿ
ಬೇರೆದೆಲ್ಲ 50% ಮಾಡ್ತಾರೆ.
ರಿಜಿಸ್ಟರ್ ಲೈನ್ ಅಲ್ಲಿ
ಫುಲ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಾರಾ ಇಲ್ಲ ಫುಲ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಾರಾ ಇಲ್ಲ
ಮೂರನೇ ತಾರೀಕು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತಾನೆ ಅಂತ ಕ್ಲೇಮ್ ಇದು ಇಲ್ಲ ಮೇಡಮ್ 30 ಇರಪ್ಪ ತಗೊಂಬರ್ತಾರೆ ಇಲ್ಲಿ ಅಷ್ಟೇ ಮೇಡಮ್ ಗೊತ್ತಾಯ್ತು ಬಿಡಿ ಮೇಡಮ್ ಇವಾಗ ಲಾಸ್ಟ್ ಆಯ್ತಲ್ಲ ಮೇಡಮ್ ಡಿಸೆಂಬರ್ 4 5 ಅದು ಬರೀ ಇದಷ್ಟೇ ಅಲ್ವಾ ಡೇಟ್ ಅಷ್ಟೇ ಅಲ್ವಾ ಡೇಟ್ ಅಷ್ಟೇ ಅಲ್ಲ ಅರ್ಲಿಯರ್ ಬೆಳಿಗ್ಗೆ ಆಗಿದ್ದವ್ರಿಗೆ ಡಿಲೇ ಕಂಡೋನ್ ಅಂದ್ಬಿಟ್ಟಿದ್ರು ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು ಅದಕ್ಕೆ ಡಿಲೇ ಎಲ್ಲ ಕಂಡೋನ್ ಮಾಡಬೇಡಿ ಜಸ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಅಷ್ಟೇ ಸರ್
ಎಷ್ಟು ಡಿಸ್ಪೋಸಲ್
ಅವ್ರ ನಂಬರ್ ಏನು ಮೇಡಮ್ ಹೇಳಿಲ್ಲ ಹೋದ್ರ ಅವರು ಅದಕ್ಕೆ ದಾರ ಕೊಡಿ ದಾರ ಸ್ವಲ್ಪ ಹೊತ್ತು ಇರ್ತೀನಿ ಫೋನ್ ಮಾಡಿ ಹೇಳಿ ಪರವಾಗಿಲ್ಲ ಅಲ್ಲ ಡೇಟ್ ಕೊಟ್ರೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು ನಾವು ಹೌದಾ ಅದು ಮತ್ತೆ ಇನ್ನೊಂದು ಮೇಡಮ್ ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಅದನ್ನೇ ಸ್ವಲ್ಪ ಅಟೆಂಡ್ ಮಾಡ್ಬಿಡಿ ಬೇಗ ಡೇಟ್ ಇಲ್ಲ ಅದೇನ ಇದು ಅವ್ರು ಕೊಡ್ಬೇಕು ಯಾರಿಗೆ SMG ನಮಸ್ಕಾರ ನೋಡಕ್ಕಲ್ಲ ನೀವ್ ಹೇಳಿ ಸರ್ ಇವಾಗ ಸರ್ ಅವರಿಂದ ವೇಟ್ ಮಾಡ್ತಾವ್ರಿ ಹೇಳಿ ಸರ್
ಆ 3140
ನಂಬರ್ ಹೇಳಿ 3140 ಅಷ್ಟೇ 4025 25 ಅಲ್ಲ ತಗೊಂಡು ಬಿಡ್ಬೇಕು ಚೆನ್ನಪ್ಪ ಯಾವ್ದೇ ಡೇಟ್ ಇದೆ ನೋಡೋಣ